பேர் கொடுமா ஸ்ரீமதி தயிர்
Your Lordship, kind permission. Serial number 71, contempt case. Site is allotted to me. They have challenged the allotment. That is, writ petition is dismissed. Now they want to sell the site to somebody else. Hence, they filed contempt. If you notice goes, they may stop it. Office objection is regarding why the president of the association made a party. Because at his best, all these things said, I made him a party.
So it is for office objection. It is under the head of office objection.
Yes, my lord.
What do you want? 3 weeks time is granted.
Time, there is no time. Then it was in 21. 22, again, order is confirmed by the authorities. They filed writ petition, dismissed in December 2023. And even after 8 months, no site, now they want to sell the site, bifurcating the same. If they sell it, again, I may have to file one more writ petition or seeking alternate site.
So
If
what
notice
do you-
goes,
What do you want?
and now I want matter to be heard so that whether there is contempt or not.
Monday, list. Office objection is dispensed with to be listed on Monday. Monday. Why accused number two is made party? Respond to.
Order, the president of the association, though not is involved, it's only secretary, but she obeys his order. Hence, he is made a part. It is his allotment. Everything is right from him only. Annexure A for a moment can be looked into. Allotment is by the president of the association. Annexure B, C, D, everything is by president. Thereafter, when there is a direction to allot the site, he is bound by the order of authorities as well as his own.
Which direction you are seeking to comply with? It was your petition?
Pardon, my lord?
It was whose petition? No.
It will tell.
Which direction you want to comply with?
Petition is their petition.
Monday, list it Monday.
Lordships, kindly.
My lords, I would like to move a writ appeal, my lords. I was the petitioner before the single judge. I challenged an order of the assistant commissioner where he granted status quo over my property in proceedings where I was not a party. I have constructed 15 floors. 2 third parties are squabbling, and the assistant commissioner grants
It
status
will
quo.
be listed, then you argue when it is listed.
My lords, may have it on Tuesday.
Not possible.
Lordships, kindly.
Yes.
Not petitioner's appeal.
There's once you remove the office objection.
Writ appeal filed by petitioner. Not the petition was filed challenging an examination for recruitment in Karnataka Power Corporation Limited. That exam was conducted in violation of certain C&R rules. Now, my lord, the urgency is they are proceeding with the recruitment process. Not in 1 week, they will finish it. I request your lordship to have it on Monday.
Proceedings, what? Recruitment.
Recruitment, my lord, in Karnataka Power Corporation Limited. There was an examination conducted not in violation of certain rules. Unfortunately, my lord, that was not considered. Now, my lord, the urgency is in 1 week. Request not 6th Tuesday.
Sixth.
Great.
My lord, serial number 24, contempt.
Serial number 55, I place a week's accommodation. I'm for the petitioner.
55.
Please, my lord.
So what do you want?
I want a week's accommodation.
At the request of learned advocate, sir. What is your name? Sridhar Prabhu.
My-
What is your name?
No, I am for the petitioner, my lord. BV Vidyalata for,
What is your name?
my name is Raja Yogaman.
For the petitioner, stand over to 3rd September.
Lord, serial number 24, contempt petition for the accused. The affidavit is ready. Unfortunately, the certified copies are not ready. We're getting it on Monday. I've informed other state council. Kindly give
24.
25 for the accused. I've already informed her.
24.
24. I need 2 or 3 days time, probably on Tuesday or whenever
12th of August,
Obliged.
12th August.
Much obliged.
Lordship, list two, serial number 3, Lordship, appearing for petitioner. Senior is unwell. List two, serial number 3, Lordship. Senior is unwell, Lordship. Hence, praise for short accommodation.
No, why? Let it be called out.
Senior is unwell. Lordship. Senior is unwell, Lordship. Hence, praise for short accommodation.
You remain present when it is called out. At that time, we'll consider.
List two, still number 1, to Sagar BB.
The petition.
Filing the affidavit.
Your notice was not issued.
Notice is ordered.
Order.
Notice.
Your Lordship has directed me to file an affidavit. I'm filing the affidavit.
This is the disability.
Yes, sir,
Yes,
this- Para 3 of the affidavit.
Engineering courses is entitled. Medical course is not entitled.
Medical course minutes, they were held minutes are not entitled.
Not
Minutes in the
entitled.
previous date minutes, I had placed on record minutes and interim order passed by the Supreme Court minutes. With regard to minutes, how the assessment was made. Minutes, your lordship had directed me minutes to produce minutes, the final order that was passed minutes in the petition. The SLP minutes is allowed. Minutes.
But here board gave very favorable opinion. That he is entitled to be considered for medical course.
No, my lords.
There it is a specific.
My lords, in the interim order that was passed, my lords, by the Honorable Supreme Court, my lords, it was, my lords, for reassessment, my lords, of his disability. My lords, the board, my lords, did not reassess, my lords, but it stood by, my lords, the assessment that was made earlier. My lords, the board, my lords, did not specifically say that, my lords, he is fit for medical course. As, my lords, there was no directive, my lords, by the Honorable Supreme Court, my lords, to that effect. My lords, taking that into consideration, my lords, and placing reliance, my lords, on the notification dated 13/5/2019. My lords, Supreme Court held that, my lords, is eligible. My lords, taking the whole body into consideration, my lords, his disability, my lords, is assessed by the board at 50%. My lords, my case also, my lords, is at 50%. My lords, I have also placed reliance, my lords, on the very same notification. The board, my lords, does not specifically say that, my lords, I am entitled. My lords, because, my lords, the board had, my lords, denied PWD quota, my lords, for medical course, the petitioner was before the Honorable Supreme Court, my lords. Board, my lords, did not, my lords, favor, they said that, my lords, 50% disability and they're not considered.
Here, where is the opinion of the board?
It, with the affidavit, my lords, it is placed on.
I have
Where is it?
annexed along with this. The document your lordship asked me to, my lord,
Something,
file.
there is no elaborate.
There is no elaborate assessment, my lord.
We are open
three-
for, my lord, if your lordship's permit, my lord, we'll, my lord, let it be assessed, my lord, by another board. We are open for that. Whatever comes, my lord, in a seal cover, last time your lordships have done that. Because here, shorten ಆಗಿದೆ. There, my lord, the board has not given the opinion whether he is eligible for medical or no.
You are held entitled for veterinary?
No,
No.
no veterinary, but engineering, yes, that is what.
Change.
My lords, medical, dental and veterinary, my lords, they have denied. However, my lords, they have held that, my lords, I am eligible for this quota, my lords, only for engineering.
So you are aspiring for what?
My lords, medical,
Medical.
medicals.
In general,
Yes, my lords.
or veterinary also?
My lords, if I am held to be fit for medical, my lords, the other two courses, my lords, would follow, my lords. The rigor of requirement for medicine, my lords, is on a greater.
Because there is a MCI regulation. Well, normal by a different board in a government hospital, boarding hospital. This is Victoria, boarding hospital, it could be referred.
Who will constitute? We should.
No, yes, no, there the head of the department will do. Last year ophthalmology, your lordships have done it.
You are KEA.
I'm KEA, government have to.
You can constitute.
No, I cannot, but they have to constitute.
Lordship so direct, then we constitute.
Will direct the dean of the government hospital.
Lordship issues a direction.
Dean,
Dean.
director of the government.
Let him be examined by a HOD of the orthopedic department. HOD of the orthopedic department, my lord, would be. But they should not be the same persons that you have to ensure. We didn't know. I'm not sure how to go. That one is so. Our ಹೆಸರುಗಳಿದೆ. ಅವ್ರು ಬಿಟ್ಟು ಬೇರೆ ಮಾಡಕ್ಕೆ.
Write down the guidelines, guidelines available from the provisions of the Rights of Persons with Disabilities Act 2016 and the regulations on Graduate Medical Education Act 1997 indicate that in order to be eligible for PWD physically,
Persons with disability.
what is it? Persons with physical disability, quota, PWD quota. For the purpose of admission to the medical courses, those who have the disability between 40% to physical disability from 40% to 80% at the maximum are entitled to be considered for their candidature in such quota. The petitioner herein has come up with the case that he has overall physical disability to the extent of 50%, which was assessed by the committee duly constituted. Still, however, full stop. Still, however, since the candidature of the petitioner was not considered by the authorities for admission to the MBBS course, MBBS and other courses, the present petition was filed. Paragraph, learned advocate Mr. Ramesh for the respondent Karnataka Examination Authority. Respondent to Karnataka Examination Authority. Integrate KEA appeared and he today filed his affidavit. It was stated in the affidavit, the petitioner, who is 2024 NEET qualified student, has claimed MBBS seat under the quota reserved for PWD, P capital, W small, D capital. It is stated that the case of the petitioner was referred to the medical board constituted by KEA, consisting of 4 medical doctors and a doctor in veterinary university, for the purpose of assessing the disability, extent of disability. In the affidavit, in paragraph 3, it was stated thus, in bracket portion, the petitioner along with veterinary courses. According to the report referred to, according to the medical test report referred to in the affidavit, it is stated that as per the opinion of the board, the petitioner suffers from post-sequel SEQUALE of left shoulder with stiffness, with weakness and shortening of left upper limb near from our post-single full stop. In other words, the stand is taken, paragraph, that the disability, kind of disability which the petitioner having would not entitle him to seek admission in medical or veterinary courses. However, his case could, however, he may be eligible to engineering and BSc nursing course. Learned advocate for the petitioner, Mr. So and so, so and so. Submitted that what is indicated in the report is the only, is the only, is that, is only that the petitioner is ineligible. The qualitative evaluation of the disability in the context of the medical and veterinary courses aspired to be pursued by the petitioner has not been undertaken. He relied on decision of the Supreme Court in Mambania Sagar Ashrambai versus Union of India, which was special leave petition. Where is that number? Special leave
18017.
petition number 18017 of 2023. Finally decided on. This is final order.
Yes, Manoj, this is the final order.
Third
Manoj.
October.
Petition is disposed of.
3rd October, on top it is.
3rd October 2023. Full stop. In light of the totality of circumstances emerging from this court is the view that interest of justice would be subserved if the petitioner is made to undergo one more medical examination in which the team of doctors shall specifically assess and evaluate the 50% disability of the petitioner, which is an overall disability, specifically in the context of the eligibility of the possibility of the, in the context of possibility of the possibility to permit the petitioner to pursue the MBBS and veterinary courses having regard to the requirement, physical requirements needed by the candidate for the purpose of said courses. The team of doctors shall undertake, in addition to medical evaluation, from a qualitative assessment of the disability of the petitioner in the above context. Paragraph. The respondent number 2, Karnataka Examination Authority, is directed to constitute a team of,
Or 1 minute. Government, let government come.
yeah, sorry, the state government represented by learned additional government advocate Mr. So and so is directed to constitute, is directed to, who will you are appearing for? State. Directed to ensure that the director of the government hospital constitutes a team of 5 doctors, whom shall include a doctor who is having the doctor in the veterinary branch. The team of 5 expert doctors shall examine the case of the petitioner in the above light and submit its report with reasoned reports
Sealed cover.
after undertaking the medical as well as qualitative assessment of the disability of the petitioner. Full stop. Such exercise shall be completed within 1 week,
2 days.
If they can do it within 1 week.
within 1 week. And the report shall be made available on the spot of the proceedings before the next date. Stand over to 2 days, 13th, stand over to 13th.
One request, my lords. Your lordships have said medical and veterinary, my lords. Your lordship may kindly say medical, dental and veterinary.
Medical, dental and veterinary.
Your lordship,
Wherever,
One more request, my lords. My lords, till such exercise is completed, my lords, if they were to commence with counseling, one seat, my lords, under SC PWD quota may kindly be kept vacant, my lords, if I were to succeed.
when the counseling is going.
Counseling, my lord, another, next week it may start, my lord. Option entry will start. Option entry will allow him. Results, my lord, it may take a little later. That's the reason I requested, my lord, if that could be, whole exercise could be done within, well, next week or so. He has to present himself before the board.
I'll be present, my lords, on whatever they did.
When the counseling is going.
Well, we are not yet, schedule has not been opened.
So you write down that. We'll say that constitute the board and the petitioner shall appear before such board on Wednesday.
Yes, my lords. I'll
That is on.
Yes.
No, no,
7th.
Wednesday, not Wednesday. Today is Thursday.
Yeah.
Ah,
Monday,
Wednesday.
Monday, let him.
Wednesday, Monday, Wednesday, and the report shall appear on Tuesday,
Very well.
and
I'll
the
appear on-
report shall be
yes.
submitted on Thursday. This matter shall be listed on Thursday, that
Thursday.
is 8th of August. 8th of August.
May make one
So
request.
is it likely that counseling is to take place?
My lord, All India has to get over. Till that, my lord, we will not. That's the reason. Till Wednesday, my lord, they may not. If that is the so, my lord, I'll ask my friend to move the matter.
That's my only apprehension is, my lords, if they were to select somebody, my lords, I will
No,
have
no,
to make him a
selection will
part-
not happen. That I can assure.
That is
Selection
very
will
well.
not happen.
Sir, I'll wait till Thursday.
Because this will not, my lord, deprive another eligible student, my lord.
If it is announced, you move.
Yes, my
Yes,
lords.
that is
I'll
what I,
meet
yes,
you.
yes. My lord,
Keep
the
your
lordship may refer to, my lord, this annexure D notification. In the light of that, let them assess. That is the medical council, National Medical Council regulations. That specifies, my lord, the, for medicine, that your lordship may refer, so that they will assess on those lines. Annexure D,
Where is that?
annexure D, my lord, page 30.
30.
And page 31, my lord, is the,
So examination by the team of doctors shall be in light of
yes.
what is
Yes,
contemplated
yes.
in Medical Council of India notification dated 13th May 2009.
Please,
Yes.
Full stop. Learned additional government advocates shall make available to the team of to the head of the team of the doctors, the copy of the said note.
he copy about it. Two 30.
It is to be noted that in Pambaniya Sagar Vasarambai, the Supreme Court, while passing interim order dated 22/9 Supra Vasarambai Supra, the Supreme Court, while passing interim order dated 22/9/23, observed thus. Then paragraph 9, court kernel. When we are transcribing the directions to the team of doctors, add this paragraph. The panel of doctors shall examine the petitioner with reference to the above. 7. Paragraph 9. Court file. The examination shall take into account the above observations and the petition shall be examined in the above light.
We have the order,
Copy of the order shall be made available to learn an additional government advocate for its onward transmission and implementation.
It's number 2. So Ajay Kumar Patil.
This could be called along with in the afternoon, my lord. Here again, my lord, OCI, he is seeking sports quota in this.
I appear in 2.1.
Afternoon, give me one. This is not sports quota. This sports quota.
Sports quota, and OCI seeking a sports quota.
This is same matter you would say will not survive.
No, the other matters, this has come for the first time. The other matters, my lord, they are.
For reading. Give me.
Plus the other matters, my lords, 2.1, 2.2 and 2.3, may be dealing from this and had another day, my lords. Because we are not claiming any quota or anything. We are just saying treat us on par with Indians.
That we have done so.
Yes, that is.
We have
have
considered them, then nothing survives in the petition.
They are covered.
It's covered
Yes,
by the.
Covered.
Notify on Monday.
Then-
Will notify on Monday.
Very
Yes,
2 point. You are.
2.1, my lords.
What's your name?
Naman.
So 2.1, 2.3,
2.1.
both shall be listed.
Yeah.
Both the petitions will be listed on 5th of August.
2.2 na ಹೇಳಿ correct ಆಗಿ.
2.1, 2.2 and 2.3.
Whole 2.3.
Still number 3. Anil Kumar.
My lord, I am appearing for respond number 2.
Petition.
I pray for short accommodation to file statement of objection, my lord.
You on time.
Yes, my lords.
Not in this case, I'm for
Connect.
responding.
I am for respond number 2, my lord.
NCISM has to be made party in this case, my lord. We have received a notification in the morning.
Why this is coming up? Already interim order is passed.
NCISM is not made party in this. They have to be made party in this.
We will.
Learned advocate for the petitioner seeks permission to implead National Medical Commission as party respondent. Yes. You appeal. Before a joining party, you appeal. Before it is joined, your appeal. Party respondent, permission is granted. Notice to the newly added party, returnable on. You're already protected. 2nd of September, learned advocate miss.
I am appearing for respondent two, my lord. I will file
Mansi.
statement of objection.
Mansi Kumar appears and accepts notice on behalf of. So 2nd September.
December 4.
Yes, I am
So you are
fine.
getting.
Respondent.
I beg for 2 days time, my lords, to attend the office objection raised on IA, my lords.
4 is not student matter. It is PIL. So it will not be listed in board number 2. Let it go regular.
Please. I will attend. Meanwhile, I may be permitted to attend the office objection, my lords, raised on IA.
Whatever.
Please.
Office objection shall be removed within 2 weeks, put upon 7th, put upon 5th September.
Please.
List ones, contempt matter, seal number 1. To Manjunath HR.
For the respondent state in this matter, your lordship.
Lord, the annexure A is the order passed by the writ petition, whereunder the respondent 1 to 3 are directed to consider the representation of the petitioner, my lord. Despite giving notices and
Notice returnable on 4th September.
Seal number 2. To Chandrasekhar L.
Same notice returnable on 4th.
Seal number 3. To Srikanth VK.
Or the civil contempt petition filed by challenging the violation of trial court order and also order of this writ petition.
Where is the order?
My lord, the stay order was passed by this honorable.
Where is the order under contempt?
Annexure C, my lord,
Page?
page 95. Kindly pardon me, page number 113, annexure D. Annexure D, my lord, accused gave undertaking
Page
that
90,
they gave undertaking that they would not intend to remove any of the
page.
page 113, 113, annexure D. This page number 114, my lord. I'd like to read this. The civil court is persuaded to grant interim order as aforesaid only because the asset purchase agreement with the first petitioner, which is binding and acted upon, is described as a non-binding nominal agreement. The interim order is despite the plain assertions demonstrating that the respondents are not in possession of the subject premises. The petitioners was entitled to use the intellectual property rights given the terms of the assets purchase agreement. These respondents' real grievance is as found in the plain paragraph on cause of action. And even if the plain assertions are taken as true, these respondents to the best could have claimed for money and none else. The cumulative effect of the interim order granted by trial court is to bring a standstill, a running concern. The petitioners do not intend to remove any assets from either schedule or B properties. Here, accused is giving undertaking that they would not intend to remove any of the assets. But immediately, my lord, they have disposed all the assets. So under section 2 clause B, the civil contempt means even the willful violation of undertaking also, it amounts to civil contempt. My lord. And before approaching this honorable high court in filing this petition, they have also received the advanced money for sale consideration through check. Well, so with dirty hands, they approached this honorable high court and they obtained the stay order by giving this undertaking. I have produced even check also, my lord, in page number 135.
Notice 9th September.
So nice.
Number 4, Mr. Sampath.
Complaint, my lord, the second round of litigation. Lord, the earlier contempt petition disposed on an undertaking of the then, my lord, the accused person to comply with the order, my lord, but this still, my lord, has not been completed. Page number 8, annexure A, the earlier contempt of this.
9th September, notice.
Plus, the standing counsel who was appointed, my lord, can be, his name be shown, my lord, Mr. Ravi Shankar, my lord.
Ask office to show you. Yes, next.
Obliged.
The PL matters. Seal number 5 to Satish KN.
I am for the petitioner in this case, my lord. In this case, my lord, I challenged the endorsement issued by the respondent on 2/1/24, which I complaint given on 2016, my lord, that illegal regularized the service of the respondent number 7 to 53, my lord, in the department of the 6th respondent department, my lord. Earlier occasion, when I given the complaint, the first respondent given the instruction to the second respondent to conduct the inquiry, and my lord. Second respondent issued letter to the respondent number 6 to conduct the inquiry. Is conducted the inquiry, my lord. He informed that there is some irregularities in that appointments, and who is not having the position of the qualification, and daily wages and contract employees are regularized, even though there is no sanctioned post is there, my lord. That is there in annexure H, my lord. And inquiry was conducted, report was submitted, my lord. Subsequently, that in that report, they have submitted that some of the employees are retired, and then the respondent number 1 sought for who are the retires and details. They are not, my lord. Several correspondence between respondent number 1 and 6 has happened, my lord. Subsequently, this endorsement we issued after lapse of 8 years, my lord, that this cannot be entertained now.
How many are regularized? 57.
Yes.
57 employees are regularized.
50,
57 or 52?
53.
Why you are worrying about the regularization? Who are you?
I am the RTI activity.
Public spirited.
Yes, public.
It is done, Mr. on the, any of the orders of the court
Yes.
and in light of the contempt petition. Sorry, dismissed. You are appearing.
Yes, my lord. I appear for respondents.
Dismissed.
My lord, 1,
We'll record your appearance. That is.
not paragraph 3, he says he is personally aggrieved by the issuance of the endorsement.
Green bench matters. Seal number 6. B. Vijay Kumar, party in person. Dr. K.B. Vijay Kumar, party in person. Seal number 6.
Appearing for the government,
my lord.
This is a
Another PIL worker, same river, Rishabhavati.
similar PIL.
He said that this maybe MP and pollution board coordinate.
There's one more PIL. Where reports have already
Mohan.
been.
Yes.
Yes.
Same.
Yes.
Same. Where is party in person?
Dr. KB Vijay Kumar, party in person.
In the second half, we'll pass the order.
Please, ma'am.
No.
Case number 7.
I appear for the petition, my lords. My lords, we have come on record yesterday, my lords, or maybe a week time may be granted.
Appearing
For
for
the-
respondents, my lord.
We have to receive few documents, my lords.
By your own time.
My lords, I pray for a week's time, my lords.
Then it will go to 3rd of September at the request of learned advocate for petitioner.
Petitioners, my lords.
Send over to 3rd September.
Case number 8. To Vasant Kumar.
Earlier, my lord, this was filed before the Honorable High Court at Dharwad, my lord. Notices are issued directed to file counter, but they, my lord, thereafter it was found, my lord, it belongs to, the roster is before your lordship, my lord, green bench matter. Yes, come, my lord. My lord, approach road, my lord, inevitable, my lord, I prepared approach road also. They say we don't pay you for the approach road. Notice has to go, my lord, they will answer. Approach road, my lord, while putting up that Malapapa project, my lords, it was inevitable that, my lord, while lifting the Senate, there was no other choice except to make the road, my lord. Approach road I have done. They are not paying that amount, my lord. In fact, to others they have paid. That is the notice we issued, my lord. In fact, notice was issued before High Court at Dharwad. Their lordship said it comes to the green bench, therefore matter has now again come, my lord.
My lord, I take notice for all the respondents.
PI?
No, my lord.
No, not PI. Since it, my lord, pertains to, my lord, sand matter, green bench, my lord, your lordships have got power to. Response 1 to 5, all government parties.
Twenty-fifth September.
Very
Right.
great.
Case number 9.
Learned additional government.
And for the
advice.
petitioner,
Yes,
similar
locus,
order is
for
passed in.
waivers, Accepts notice
Uh,
on behalf of the state.
My lord, in
Number 9.
other matter, an order is passed in respect of same notice challenged. Only parties are different, my lord.
What is that? What is that?
The copy. I don't know what order it is. I don't know, an order on the bench of the president.
Paragraph 4, liberty was given to the petition in the said matter.
So your case is that you are not liable to be registered.
Uh,
That is your case.
We are small scale industry, that is small scale industry, that is what the case on the part of the petition. Annexure A, the notice issued by the second respondent.
My lord, could I?
Or learned advocate Mr. So and so for the petitioner and learned additional government advocate Srimati Neela for Akbar for respondents upon service of copy of the petition in advance. What is sought to be called in question in this petition filed under Article 226 of the Constitution, comma, is notice dated 24/28/8, 24/28/8/2023, whereby the Deputy Director of Department of Mines and Geology, Tumkur, Response number 2, here has required the petitioner industry to seek and get registration under Rule 15 capital B of Karnataka Minor Mineral Concession Rules 1994. Paragraph. The notice is indicative that it is a notice issued under Rule 15B, the aforesaid rules, as amended in 2023. It requires the petitioner industry to register within the period of 90 days and pay the registration fees. To further state that the failure would entail the imposition of fine, levy of fine. Learned advocate for the petitioner would submit that paragraph. The petitioner is a small and micro scale industry which would not fall within the purview of aforesaid rule and therefore shall not be liable to be registered. Be as it may, paragraph. The challenge is only to the notice. Government advocate could submit that in Messrs. Santala, SHANT, HALA, Santala Marbles and Granites versus State of Karnataka, which was writ petition number 14024, 2024. Similar fact situation was posed POSCD before the court, wherein similar notice was under challenge, and that the court relegated the petitioner to the authorities permitting the petitioner to file a claim. Paragraph. Since the Controversy is only at the notice stage, and the petition is filed at such stage. The petitioner is at liberty to respond to the notice. Paragraph, the competent authority shall decide about the registration of the petitioner industry strictly in accordance with law, as per the rules and after taking into account the stand of the petitioner. Paragraph, this court has not expressed any opinion on the merits of the case of the either side and has not gone into the merits. The petition is not entertained accordingly, as it is premature, relegating the petitioner as above and requiring the authorities to take decision to complete the entire exercise within 2 months from today.
Oblige.
Petition stands disposed of in the aforesaid terms.
Notice directing me to stoppage the calling of activities. Annexure A, page 22, 21 is under challenge. Law is well settled, my lords. When a lease period is subsisting, the authority cannot direct for stoppage of quarry activity. The impugned order is in violation of principles of natural justice. No opportunity of hearing was granted to the petitioner. An unilateral order is passed by the authority.
My lord, please see the reason why we have temporarily stopped, my lord, the quarrying. Paid annexure, translated copy of annexure A, page 21. My lord, the second paragraph. My lord gets it.
So boundary marks are to be,
Since there are disputes between so and so, in the matter of boundaries of the stone quarry lease, there are possibilities of casualties due to fights in the matter of boundary dispute. My lord, it may lead to law and order problem, fight between two individuals with regard to a boundary. My lord, let them settle the boundary dispute and come before the authorities, my lord. We have no problem. Keeping this alive, we do not know where the spots are, and even the quarrying plan is not produced. They don't deny this fact.
you survey the boundary marks.
My lord, but they should come forward.
Their boundary is already fixed.
You are fighting with somebody, your neighbor.
Yes,
Injunction is already granted. That is also is a matter of record in the present petition.
then let him give a reply to this notice
This
and
is
go
all
before the authority, my lord, saying that
Motivated
there is
complaint.
no boundary dispute. It has been decided in a civil suit.
My lords, all that, let them issue notice, grant me an opportunity of hearing. Thereafter, let them pass an order.
Can
in
you
accordance.
don't have the powers to resurvey.
My lord, resurvey, provided they come with an application, my lord. We on our own, we cannot do resurvey because then we will, it's like showing personal interest. The other person has to come forward saying that he has encroached upon my land and so my boundary line gets extended.
My lords, this is a motivated complaint at the instance of the complainant. They have
That we are
initiated
not
this
aware.
notice. My lords, they should grant me an opportunity of hearing so that I can enlighten the authority saying that these are factually incorrect. My lords, I draw my lord's attention to the cital plan, which is a subject matter of the lease. Kindly see, my lords, page 61. Page 61. The quarry properties is at western side. Western side. Kindly see page 61.
My lord, may I make one
It is
submission?
nothing to do with the adjacent property of the landowner is concerned. It is totally a different area.
My lord, may I make
All
one submission?
motivated complaint, my lord, for which an opportunity is not granted to me to have my say before the authority.
My lord, may I make one submission? My lord, let this notice be treated as a show cause notice. My lord, and then notice may be issued to both the parties.
We'll do the same.
Yes,
thing. We'll do that. Third learned advocate, Mr. Sachin B.S. for the petitioner, and learned additional government advocate, Srimati Neelofar Akbar for the respondent state and its authorities. Mining authorities. Upon service of copy of the petition in advance. The challenge is sought to be addressed in this petition filed under Article 226 of the Constitution, paragraph 2, notice dated 25/6/24, issued to the petitioner by senior geologist, Department of Mines and Geology, Udupi. Dash respond number 1 herein. Neelofar Akbar appears for the respondents at the respondent authority, state nailing. Respondent authorities. This paragraph continue. The side notice is in respect of the stone quarry lease number 445 in the area of 2 acres in survey number 176 in /1 in Kalya village, Karkala Taluka, held by the petitioner. Notice mentions paragraph that the petitioner and the adjoining quarry holder, one Sri Dinesh Shetty, who has his quarry in survey number 176/4, are at dispute in the matter of boundaries of the respective quarries. Because of the dispute and in fight between the two, it is stated that there are possibilities of casualties due to fights in the matter of boundary dispute. The authorities thus apprehend breach of peace and is concerned about the law and order which may worsen due to the boundary dispute between the two quarry holders. It is stated that in that view, the matter was referred to the Deputy Commissioner, who was instructed to temporarily cancel the stone quarry lease till the boundary dispute is resolved between the two. It is also ordered to temporarily stop the operations in the quarry lease of the petitioner. Paragraph. The main ground of challenge of the petitioner is that the aforesaid order is passed without hearing him, which is therefore prejudicial, and that he has no occasion to put forth his case. Paragraph. In the totality of circumstances, the court is not inclined to interfere with, since it is a so cause notice, however, following order is passed. 1. The competent authority to the respondents, 1, shall call the petitioner as well as the said joint as well as the said adjoining quarry holder, Sri Dinesh Shetty, to provide both of them the hearing. 2. The boundary dispute shall be attempted to be solved by fixing the boundary of both the quarries. By the rules of the competent authority shall undertake the said exercise after hearing both the sides of fixing the boundaries. Paragraph. The intimation shall go to both the parties who appear before the authority and the entire exercise, including the fixation of the boundaries, shall be completed within 10 weeks,
Obliged.
10 weeks from the date of receipt of the order. Paragraph. The after solution of the boundary dispute, the petitioner may be permitted to restart. After solution of the boundary dispute, the petitioner may be permitted to restart his operations. As expeditiously possible and preferably within, and in any case, within 8 weeks.
Very well.
8 weeks.
My lords.
The petition is accordingly disposed.
My lord, may I make one
We're
submission?
not permitting you to carry on.
No, no.
Because law is in my favor. Law is in my favor.
Pardon?
Unless the lease is cancelled, I cannot be prevented from carrying on the mining of, that's what the view which is taken by the division bench.
No,
of
let
this.
it be. Otherwise, there
There is no power to stoppage of quarrying operation unless when the lease is in operation. Invested huge amount, these aren't all political motivated.
My lord, that's the reason why my lord has said expeditiously within 8 weeks. We don't want to have a bloodbath, my lord. They can wait.
We do
They
not
wait.
know. High sounding words.
No, I'm sorry. My lord, it's just that in the interest, we don't want to have any law and order. We'll see that it is done expeditiously, but till then, my lord, no operations.
Then you complete it within 4 weeks.
My lord, with the rains and all, 6 weeks, my lord. may have
6 weeks.
Obliged. Lord, my lord,
But only thing which pinches us is that you have not stopped the operations of the other parties. That really puts him to prejudice.
my lord, that is there, but
Invested
very well,
huge
within
amount.
6 weeks. I don't know if a notice has been issued to him,
Say-
whether he is also,
On the only ground that the principles of natural justice are breached while passing the order is set aside and the following order is passed. So whatever it means.
no, my lord, if that is set aside, my lord, then he will start the operations, my lord. There'll be a law and order problem. My lord, it's just 6 weeks I'm asking for. Notice must have been issued to Dinesh Shetty also, but he hasn't appeared before, my lord.
Then it is not equitable that the other party.
I understand my lord's dilemma, my lord, but we don't know whether my lord, he has also filed a writ petition. A notice must have been issued
lords,
to him.
There are possibility of fights. All this law and order problem is not narrated in notice at all.
My lord,
There
and the
may
very
be
fact
possibility
that-
of fights. That's what
My
they
lord,
say
and
in
the-
the notice.
My lord, and the very fact that a notice will be issued to Mr. Dinesh Shetty also by the senior geologist, my lord, that also is there.
Notice is not issued to other party.
My lord, that I don't know, my lord. It must have been issued, but I don't know if Mr. Dinesh Shetty has come forward to file a writ petition. My lord, that the whole this thing of maintaining law and order, my lord, will become my lord, it'll be it'll be problematic, my lord. Then I can get a notice issued to him also, let the writ petition be pending. Yes.
Past 1.5 years, I'm running the quarry license. There is no problem as such. Since
No,
he's
no,
the
this
adjacent
order is
owner,
passed on
he's
20
also running
notice
quarry
is-
activities coming forward to file a false complaint.
My lord, notice is issued on 25th of June, my lord. 6 weeks, my lord has granted. Yeah, then I will. Malad, then may I make one submission?
Add in the. So we'll say during 6 weeks, within 6 weeks.
My lord, in the meanwhile, no quarrying, my lord. ಏನ್ರಿ ಒಂದೇ ಕಳ್ಸೋದು ಒಂದೇ ಕಳ್ಸೋದು ಏನ್ ಮಾಡೋದು?
So we'll say set aside and pass the fresh order,
My lord, can I make one submission?
full stop.
My lord, I will ascertain.
If in the meantime, during the operation of the quarries, any incident of breach of peace occurs or law and order problem is or law and law and order problem happens, the authority shall be at liberty to order stoppage of operations.
No, my
for-
lord, may I make one submission? My lord, may I make one submission? My lord?
This is
My
all
lord-
on
no.
all apprehensive. Don't
No.
know what is the dispute, how intense, how intense it is.
My lord, may I make one submission? My lord, I will verify from the authorities whether they have issued a notice to Mr. Dinesh Shetty. My lord may have this next week, and then, my lord, your lordship may pass whatever order.
All let find out.
My lord, I will,
Simply notice returnable on. That is better.
yes, much obliged.
Sixth,
Yes, yes,
6th of August,
obliged.
learned additional government advocate. Type out this order, keep with you. But today order will be on notice.
Can I request for stay?
On that day we'll see.
Obliged, my lord.
We'll have a better idea on that.
This number 11. The writ appeal matter, Rajendra Kumar Shingai.
Where for appellant, my lord, in this case. Where for appellant, Lord, it is a appeal by the university. Lord, against the very order, my lord, the UGC also has prepared an appeal, writ appeal. And that matter also, my lord, has been tagged along with this. And not for 950. Notice I. There was no recognition, my lord, during the period for which the student has
What is
admitted.
the
to this.
problem?
Lord, the problem is, my lord,
Yes.
the UGC had discontinued its recognition, my lord, to the
That,
appellant university. And during that period, my lord, in spite of issuing a public notice by,
your university,
yes, my lord, I am university,
which university?
Karnataka State Open University, who is an appellant, my lord, here. For the period of 14-15, my lord, academic year, there
The
is no.
petitioner studied where? Rajasthan?
Rajasthan, my lord, outside, my lord, that is also, there is a bar from the UGC.
So how you are concerned? You are employing? How you are concerned? Why your direction is given to you?
My lord,
No, no.
it so happens, my lord, the appellant university, my lord, was conducting distance education through its agencies and franchises. One
Study
such
centers.
franchise is
Rajasthan.
sitting in Rajasthan, my lord, where they have studied. the issue is this, the problem here is, my lords, from 2005, my lords, Supreme Court and Professor Espal has made it clear that the state universities can only act within the state.
Territory.
Question of territory, beyond territory do not apply. And secondly, my lords, KSOU, my lords, had not obtained any permission, or it did not get its permission renewed, my lords, post 2012-13 and offered courses. Hence, UGC has said it had not recognized those courses. There was no recognition per se, my lord. So in this,
So the petitioner is seeking some employment?
no, they have sought employment and they are working somewhere, my lord.
Petitioner has applied for the post of storekeeper and the petitioner is
Yes,
selected.
there, my lord, they have said that your degree is not recognized. For that reason, it cannot
Elected
be.
and offered appointment on 10/6/19.
Yes.
Reported to duty, working since then. Successfully completed probation period.
Yes, my lord. For completing of probation, the issue here is, my lord, whether the degree is recognized or not.
I appear for the writ petitioner, my lords. My
And,
lords, he has studied with the KSOU, my lords, and KSOU has issued him a degree certificate, sorry, my lords, marks cards and also provisional pass certificate, my lords, based on which he has applied, my lords. And at an earlier point in time, the university has also verified the marks cards, my lords.
So there are judgments that even if you are right, since he is in service since 2019, completed probation period, in such cases, he should not be disturbed.
My lords,
We are not with that, my lords. Here the issue is, I am appearing for UGC, my lord, University Grants Commission, my lords. We have also filed the connected appeal, 954 is filed by us, my lord. The question here is, my lords, whether such a degree can now be considered. My lords, what happened in Karnataka state, my lord, in a precarious situation, Karnataka state took a stand that we recognize those degrees. Even despite there being no recognition from UGC, we would. The
Will say-
problem of the petitioner with her employer is another thing, my lords. And one.
Or learned advocate Miss so and so for the appellant and learned advocate Miss
Kumariyam.
for the respondent or petitioner appeal is admitted, it shall be listed for final hearing.
One
My
Tenth
lords,
December.
one short.
connected matter, my lords, the office objection may be dispensed, my lords, because
Connected matter may be listed on. It is there today.
it's also there in that some office objection notes are there, my lord, that may have to be.
So this will be common order. Which is the number?
In that, we have filed a counter affidavit, my lord, they wanted a verifying affidavit.
11 So, writ appeal number 954 of 24, arising out of the same judgment and order of Lana Single Judge and preferred by the University Grants Commission is also admitted to be listed with the writ appeal, instantly writ appeal number
188.
188
Yes.
of 2024.
That office objection, my lord, that we had filed a counter affidavit, my lord, that we have produced. Otherwise, there is some.
Delay of 156, this may an order. First order in this, then order in IA in this, third learner with respect to part. IA number. 1 of 24. IA was taken up for consideration since learned advocate Miss
Kumar.
also appears for the original petitioner. Any other parties to be served?
No,
No,
my lord,
madam. State government and
Who is the-
state ಇಲ್ಲ. ಇಲ್ಲ, state ಇಲ್ಲ. State ನಿಮ್ದ್ರಲ್ಲಿ ಇಲ್ಲ. ಇಲ್ಲ, state ಇಲ್ಲ.
Not if this application could be considered at this itself as the parties are represented. Full stop, notice returnable. Forthwith, learned advocate, Mr. So and so. What is your name?
Rajendra Kumar Singh. I am for appeal.
There
Appellant.
was access notice on behalf of the number 1, whereas learned advocate Miss so and so accepts notice on behalf of respondent to original petitioner. Whose delay of 156 days, 138 days is paid to be gone down, which has taken place in preferring this appeal. Also, the accompanying affidavit spells out the reasons to explain the passage of time leading to the delay to the aforesaid extent. In the facts of the case, it could not be said that there is an element of culpability in the conduct of the applicant. Full stop. Sufficient cause is made out. Delay of 138 days is gone down. Paragraph. Application is allowed. Then order in Writ appeal number 954 of 24. Heard learned irrevocable with respective parties. This appeal arises out of time judgment and order, which is under challenge in the aforementioned Writ appeal number 188 of 24. Also, the same is admitted as per the above order. Whereas in the aforesaid view, the present appeal is also admitted to be listed along with Writ appeal number 188 of 20.
The contempt is also clubbed along with this, my lords. Hence, that order may be
All the
stayed. my
three
lords.
cases are listed today.
So we are not granting stay.
Yes. Seal number 12. Mr. Hanumantappa A.
Appellant, my lord. In this case, but there is a delay in filing the appeal, 8 days delay.
Notice returnable on 17 September.
Please, my lord.
Seal number 13. Mr. Patil Dayana.
I fear for the appellant.
Delay of 40 years.
Please.
Delay of 40 years, 35 years.
No, it's not the delay I am worried about, my lord. Your lordship may kindly see page 15. The impugned order starts at page 13. In page 15, last para, your lordship may kindly see. The petitioner has not taken any action right from the year 1979 until the month of August 2017. And the court is of the considered view that even if the petitioner has any right, it stands completely extinguished. A finding against me of this sort, I can understand the writ court saying, we don't want to exercise the writ jurisdiction, I will not entertain the petition. But a declaration against me in my petition that even if I had any right, all those things are extinguished. Actually,
So what is declaration?
I had sought for execution of sale deed. Authority said we will not do it. I did not approach the court early. Actually, in
So
the
your right-
resolution, your lordship may kindly see.
Right to relief is extinguished because of passage of time. That is what it is.
It's not, there is a difficulty for this reason. Kindly see page 31. Page 30 is the Kannada 31. Subject number 6. As per the decision of the council to sell the coconut garden 25 gunta so and so in favor of so and so is nullified as per order dated so and so of the deputy commissioner, since town municipal council has power as per amended section so and so municipality to sell the property through auction in case if the value is below 5,000. Through this decision, council subject to exam decide the application submitted by so and so, except the auction proceedings in this regard. Decision. Following decision is taken after reading and understanding the application of so and so. It is a garden land comprising of so and so. Town municipal council has also situated away from the village humid region. Auction publication is issued in the newspaper. Auctioned in public. Highest bidder applicant is permitted to enjoy the property in accordance with law. From 1977, I am in possession. It can be even part performance under 53A. I said municipality has done all this. I have paid the amount. I am in possession. You have not issued the final certificate, please issue it. They say, "No, Deputy Commissioner has refused to issue grant the permission. According to us, permission is not necessary. Even I understand, my lord, if the court were to say, you have approached after so much of delay, we will not entertain the petition. That would not have affected me. Now the court has given a declaration that all the rights, whatever I had, is extinguished. In an auction, open auction, I have purchased.
What was your prayer in the petition?
Please,
What was the prayer
please.
in the writ petition? Copy of the petition is not enough. Yes, it is. No, it is not there. Doesn't appear to be there.
A direction to execute the necessary registered documents.
Page.
No, that would be page 22, my lord. First prayer is for quashing the endorsement. Bottom, first prayer is for quashing the endorsement. Second prayer is for issuing a mandamus to register the sale deed. Even if my petition were not to be entertained on the ground of delay and laches, that would be another thing. But a declaration against me at this stage, my lord. Because admittedly, I am in possession. Municipality itself says.
What was the endorsement?
Endorsement is at Annexure J, page 48. Translation, page 49. With regard to your request made by submitting application to this office as per reference number 1 to register the land measuring so and so of Arsikere as per the decision of the general meeting held on 28/2/1979 is examined. Subject number 6 of the general meeting as per reference number 2. It appears that public auction of sale of 25 guntas of coconut garden in survey number so and so, together with the crop for 3,115 in favor of Channabasappa is nullified under official memorandum dated so and so of the Deputy Commissioner as per reference number 2. The decision at reference number 2 is examined and it is decided that Town Municipal Council has power to register the proposed land to the highest bidder and permission of the higher officers is not necessary. But the Honorable Deputy Commissioner should be requested to issue orders in compliance with 72(2). As the decision of the council is nullified by the Deputy Commissioner and at para 2 it is decided to request the Honorable Deputy Commissioner Hassan to issue the orders. But as orders of the Deputy Commissioner Hassan is not forthcoming in this regard, it is brought to your notice the fact that there is no scope to register the proposed sale. There is supposed to be an order made by the Deputy Commissioner somewhere in the year 1979. Neither the municipality nor the Deputy Commissioner's office or anybody has that order. Municipality says, yes, we have given it to you. You have been cultivating, all those things are right. But the Deputy Commissioner has not given the permission, therefore we will not execute.
Your sale is not confirmed.
Sale is confirmed. I was given possession, section 72. They don't require a permission. Your Lordship may kindly see
Then now,
section.
what did you want in the petition?
What they did is,
No, you wanted what?
I wanted a registered document to be executed. From 79,
So why it is not executed?
they say a permission of the deputy commissioner, approval of the deputy commissioner was sought, approval is not granted as per reference number 2. Some order they make a reference. Therefore, it cannot be given.
Who will appear for deputy commissioner? No.
With regard to facts of the case, there is no dispute. Only dispute is with regard to, my lord, this observation being made. For the simple reason that if this observation were to stand, my lord, then the appellant will not be able to file a suit for adverse possession.
Why don't you execute the deed?
My lord, I'll have to take instructions, my lord. But the facts, my lord, there is no dispute with regard to that. They are agreed only by virtue of this observation. It will extinguish their rights. They also accept the.
What right? Every right is enjoyed except getting the sale deed executed. So
My lord, but the title is not there.
unless,
They're enjoying it.
unless something overriding is there, this delay should not come in way to get the sale.
Please, that's
the point. If everything, is anything major is there against him or something, or some overriding circumstance is there, you point out, notice it.
The document number 1, which they have produced, my lord, in page number 26, very clearly tells the name and address of Khatadar, owner of possession holder is Arsikare TMC area. So the possession holder is still in our name only, my lord, according to the document number 1, which is produced. It is
To find
only,
it, just notice it and
only the auction was
whether some. Otherwise, we'll clarify and relegate him to civil remedy, but if something can be done and it can be put an end to, we'll put an end to here only. 21st August,
please.
notice written.
Number 14. DS Ramchandra Reddy.
May I please appear for the appellant? Matter arises under the process of the second.
You appear. So we'll say notice for final disposal, returnable on 8th of August. It is covered by one of our judges. It is covered by. We go through.
There are private response, not response 4 and 5. Who are the LRs of the purchaser?
You go through this judgment before we pass any order. It is in writ appeal number 1627. Please take 1627 of 23. Decided on
It's writ appeal, milords.
writ appeal 1627 of 23.
16
Decided on 3rd July 24.
2024.
To go through, then come.
Yeah. In the meanwhile, may I request your lordships to kindly, my lord, order notice to the response 4 and 5, because they are the purchasers.
You can get out of this order, you will issue notice. 7th.
So may I just writ appeal 1627 of 2024.
Yes, 1627 of 23.
23, yes.
Decided on 3rd July 24.
Yes, my lords.
Number 15. Revision.
My lord, the respondent number 3 was a senior manager talent acquisition. His role was found to be surplus. He was terminated. Upon his request, termination order was withdrawn and he was relieved from the job after full and final settlement. That document is found in page number 158, document number 15, my lord. Now, after the lapse of, he was relieved in the month of November 2017. After the lapse of 5 years, he approaches respondent number 2, Assistant Labor Commissioner, and files a complaint saying that he was forcefully removed from the job. The endorsement issued by respondent number 2 is at page number 80. Now, these are the observations by the respondent number 2 in the endorsement, your lordship, which is found in page number 81, the operative portion. The management has given 3 months salary in lieu of prior notice. He was a senior manager. His salary was 22 lakhs per annum. Now, for the first time, he comes before this single bench of this honorable court and says that he's a workman. For the first time. He himself has tendered his resignation.
So how you are aggrieved after direction at page 20?
My lord, now presently the matter is remitted back to the respondent number 2 officer. Now the conciliation proceedings has been initiated. My only point is that this person, respondent number 3, can never be defined as per the Industrial Dispute Act as workman. For the first time, he has raised this issue and he never raised this as an issue before the respondent number 2 authority. One. Second thing is the dispute what he is raising, it can never be considered as an industrial dispute as per the definition, my lord. These are the two ingredients, these are the 2 points which I am raising before this honorable court.
But the conciliation officer is directed to submit a report only.
Yes, my lord, because this person he's never been, can be termed as a workman, can, within the definition of the, under the Industrial Disputes Act. That is one point, because I have produced the documents, he himself has signed all the documents kindly, which is there in document number, my lord, page number 149.
That you have to submit to the conciliation office.
I have filed by detailed objections that has been considered before the conciliation officer in the endorsement dated page number 80, my lord. That is what the order which has been passed, and that order is being set aside. That's the point, my lord. Page number 81.
So you've taken a decision pursuant to direction number 2. If decision is in their favor, then this appeal will not survive.
Yes, I will get those instructions. Lord, the order is dated 8/4/2024, and the direction given is that the report of conciliation has to be submitted within a period of 4 weeks from the date of receipt. That must have been done.
One submission. Presently, the matter is pending before the conciliation officer. Conciliation has taken place, but report has not been passed by the conciliation officer. This is for the kind submission.
Before the court proceeds to consider the challenge to the impugned order on merits, how it would be expedient to know the status of the direction number 2, Roman small 2, issued by a single judge, directing disciplinary 2 to submit report of conciliation. Full stop. Learned advocate, learned government, additional government advocate, Srimati Nilokar, will apprise the court about the developments to further find out whether the report directed to be submitted by the court is prepared and submitted or not. Send over to 23rd of August.
Right.
December 16. The Ragini Bandela.
For the appellant, my lord. This matter comes under purview of KPID Act. Two writ petitions are tagged in this matter, 1584 of 2022, filed by depositors against a special court order dated 21/12/2021. And the other writ petition is filed by the company Dreams Infra India Limited Company, 401 of 2023.
You are challenging page 26 order
Yes,
dated
7/6/2024.
The interim order.
But petitioners in 1584 have filed this appeal against the extension of interim order dated 11/1/2024.
Interim order. This is
Interim order, page number 298, my lord. So there are some questions of law involved in this matter, my lord. Page number 21. Present learned single judge has extended the period of interim order dated 11/1/2024. That was already expired, my lord, and it was automatically vacated. The company has sought, my lord, company sought the stay order for 4 months only, time period for which was completed in May.
So they will go through.
Some other questions of law involved in this matter, my lord. I was not furnished the copy of the writ petition while passing the interim order, and I was not
heard at that time. Still I filed for that IA for vacation is still pending. It was not heard, still pending. And some other questions of law involved, my lord. The company has raised the contention that KPID Act is not applicable in this matter. But this contention was already dismissed. It was rejected on merits, filed by the same company in same company matter in 13477, in writ petition number 13477 of 2020. So the question arises, my lord, when the contention was rejected about applicability of KPID Act, then how can the same contention be raised again before another learned single judge? Apart from that, this matter is pending before division bench of this honorable court, my lord. And division bench in its order dated 27 February 2024, passed in PIL 7500 of 2020, and stay order dated 7/11/2022, passed in writ appeal number 1343 of 2021, directed the special court, KPID special court, to proceed with the trial and decide the matter. But on the other hand, learned single judge has passed the order not to precipitate with the matter. So that is directly hitting the division bench order, my lord. And this company has approached after 4.5 years and sought stay. And company has sought only for 4 months, which the time period for which got completed in May. But still it is being extended on every hearing date. Clause 3 of Article 226 provides for automatic vacation of stay if it is not heard within a specified time period. And if the copy of the writ petition and other supporting documents for such plea, in plea of such interim order, is not furnished to the opposite party.
Which is the other petition? 1584
1584.
is for what?
For that was against a special court order. Dated 21/12/2021.
So this order at page 27, 26 is passed in which matter?
Pardon?
Order we are challenging is passed in which writ petition?
That is in 401, but both are tagged. So it's a common order, my lord.
Common order.
Common order. I have attached that IA for stay filed by company on page number, that is in additional documents. Page number 324. And copy of writ petition 1584 is on page number 28.
Yeah. Contempt of elimination before public investment, because yes, we are deciding, we are not entertaining, but we are deciding this IA number 1 of 24. Heard learned advocate Miss so and so for the appellant, and learned additional government advocate Srimati Nilofer Akbar for the respondents upon service of copy of the petition, a copy of the appeal. One. Upon service of the copy of the, upon service of copy of the appeal in advance. In this writ appeal, filed under section 4 of the Karnataka High Court Act, the petitioner, appellant petitioner has sought to challenge order dated 7th June 24, which is the common order passed in writ petition number 401 of 23 and writ petition number 1584 of 2022. Paragraph. The order is an interim order, reading as under. For the order, page 79, 27 of it. There is no gain saying that when the order is interim order passed in the pending proceedings, it doesn't determine the rights of the parties finally. Full stop. The controversy and the disputes between the parties are at large on merits, are at large to be considered on merits by law and a single judge in the pending proceedings of the writ petitions. Full stop. There is not wrapping of finality in the order challenged in this appeal. In the aforesaid view paragraph, the court is not inclined to exercise the appellate jurisdiction and is not inclined to entertain the writ appeal against the interim order. At the same time, paragraph, the facts in the background suggested, showed that the proceedings of two writ petitions number 401 of 2023 and writ petition number 1584 of 2022 are clubbed. As per order dated 11/1/24, passed by a single judge, writ appeal number 401 of 23 came to be tagged with writ appeal number 1584 of 2022. Paragraph, the petitioners in writ petition number 1584 of 22 filed interim application number 1 of 24 for vacation of the interim stay on 5/2/24. On a single judge, however, kept the said application pending and extended the period of interim order as interim order on 7/6/24. It is this order paragraph dated 7/6/24 which is brought under challenge by filing writ appeal. Thus, it could be noticed that interim application number 1 of 24 filed by the petitioners in the writ petition number 1584 of 22 is kept pending and has remained undecided. Full stop. It is expected, it is required of a single judge to consider the said application merits and render appropriate decision thereon expeditiously. Full stop. With the aforesaid limited observations, the present appeal is not entertained.
Obliged.
Complaints in contempt matters, cell number 17. Suyo Garane.
Filing my counter affidavit minutes. I'm filing my counter affidavit minutes. It is ready. I'm filing my counter affidavit minutes to the complaint.
On time.
Minutes, it is ready. I will file in the.
For September at the request of Lana petitioner.
The complaint. May I request for a date, minute? May I request for a date?
September.
Please.
Cell number 18. GS Venkat Subbarao.
It be taken up next week, my lord? Could it be taken up next week, my lord? For the accused, my lord?
At the request of Lana, the complainant stand over 12 September.
Much. Sure.
Cell number 19. G. Balaji Naidu, hearing.
Correspondent number 7 in this matter, my lords.
Can I persuade your lordship to order dated 2/9/2022, my lord? There was a direction to connect one more similar, residents have filed one more PIL, which is pending. May I just pass on those, by mistake, my lord, writ petition is numbered as 16969. But in the order sheet, my lord, it has been typed as 16909. That petition is decided and disposed of. That is not the connected case, my lord. I'm just passing on this.
Which is the correct number?
16969, my lord.
16969.
Of 2022, my lord. I'm just passing on this. I did come along with
This
those matters.
petition came up for consideration. Learned advocate for the petitioner, Mr. So-and-so pointed out that in order dated 2/9/22, while it is directed that writ petition, another writ petition is to be heard along with the present one, the number of the said writ petition is wrongly mentioned as 16909 of 22, which ought to have been 16969 of 22. Full stop. What is the matter for?
Well, this matter pertains to unauthorized construction made by the respondent number 7. There was a tender was been floated by the respondent number 6. There is, without obtaining any sanction plan.
Both the matters may be posted on 8th September.
Grateful, madam.
Cell number 20. The BP negative.
My lordship, I appear for the petitioners in this case, my lordship. My lordship, it is a matter pertaining to direction to issue direction to take examinations which are to be scheduled at 9th of September, my lordship, 9th of August. My lordship, this honorable court has granted interim order on 7/11/2023, permitting the petitioners number 1, 2, 3 to take examinations of MBBS first years, my lordship. My lordship, and one of the student has failed, my lordship. He has also taken supplementary examination by taking the permission from this honorable court. Again, in the supplementary examination, petitioner number 2 has failed, my lordship. Yeah, he has to take examinations for the first year examinations, which are scheduled to be on 9th of August, my lordship. But by seeking permission to take examinations,
Again,
please, my lordship, he has failed.
Same one is the day before yesterday, but let it be, my lord. As far as the students are concerned, my lord has taken the same view in other matters also, so we'll take
having
it.
further
But
heard
post
learned
it for
counsel,
hearing, that's all.
having further heard learned counsels for the.
But at least, my lord, why,
Yes, it was urged by the learned petitioner, Mr. So that the petitioner has been permitted to appear in the examination past. Only one petitioner?
One petitioner,
She
petitioner number 2, my lordship.
He may also be permitted to appear in the ensuing examination commencing from 9th of August.
Please, my lordship, for the first year MBBS.
Respondent shall permit the petitioner to take the examination, which is scheduled to take place from 9th August onwards. However, it is provided that permission granted to the petitioner and the appearance of the petitioner examination shall not create any right or equity in favor of the petitioner.
only thing I'm saying is, my lord, not for this, but in the other matter, so that if some direction is issued, this year on the last day, this is not repeated. So if any of the matters are kept for hearing,
So
that
not
can be probably avoided.
very. Shall not create a right or equity. Stand out to
Apply.
21st November.
Number 21,
Lord, I appear for the.
Srikara PK.
One. Repeat. ಎಲ್ಲ ಹಾಕಿ ಹೌದಾ? Right.
This matter, an application for pleading is filed which is listed.
You received copies. Copies, you don't have copies.
Course, my lord, I'm told that there is some mistake in furnishing of copy, my lord, I should do it now itself.
But what consequences will he have? He is not a party in the single judge order.
What shall we do?
File, I've seen, I don't know what it is and who they are also.
You cannot take my letter by surprise. I was not knowing that copy was not.
I think none of us on the respondent side have got copies.
Ultimately, you want time.
Please.
But it's not,
Huh?
it's not a party. in
But
this-
I don't know who it is.
Not a
Let it
I'll
go.
take a look at it.
Give copy, then we'll post it on September first week, 6th of
Yes,
September.
sir. Earlier to that. Maybe little earlier to that, my lord.
What
Being
is
the
the
benefit, being the beneficiaries and site owners, by virtue of the litigations being pending from quite a long time.
Correct, but let it be after 4 weeks. So matters are studied on the board.
You've been somewhere in the month of August, which was
According to
Lordship's convenience.
30th August.
I'm sorry.
Number
I'm sorry,
22.
can it be on 31st? Can it be the 1st of September? I'm so sorry.
2nd September.
Second.
If there is some problem.
Second September.
Second September.
Great.
Number 22,
Please.
Bal Gangadhar DS.
For the complainant, my lord, orders have not been complied with. My lord, in fact, accused number 3 and 4, they have not been represented, my lord. My lord, in the first matter, 22, my lord, 26 is also connected, my lord. Serial number 22, my lord, accused number 3 and 4, my lord, they were served, they did not appear or engage the services of an advocate, nor they have complied, my lord. Your lordship observed the same and passed an order, my lord, on 18/6 that appropriate orders is to be passed. And 1 and 2 is represented by Madam Swathi.
So what is this?
My lord, the directions, my lord, by the Honorable Division Bench, my lord, at Annexure B1, my lord, is not complied with. They filed a SLP also dismissed, review dismissed. Please. Page, my lord, 41 and 42, my lord. Neither, my lord, they called for training. And then, my lord, in para 13, page 41, my lord, my humble submission is, my lord, I am entitled for the pay scale and other allowances and emoluments and benefits, my lord. This was not given, my lord. This exercise is to be done, my lord. Next page 42, within a period of 9 months, that has not been.
Training is held.
Well, no, my lord. Nothing, my lord. My lord, thereafterwards, SLP was filed, my lord, orders is confirmed. Then, my lord, I issued a notice, my lord, annexure F may kindly be perused. Page number 51, giving all the details of my salary, arrears and allowances, my lord. They did not come forward. My lord, my notice is also not replied in spite of serving on them, my lord. Then they filed one more RP, my lord, that is also dismissed at, my lord, annexure D, my lord.
Who appears?
Your Lordship, I'm appearing on behalf of accused number 1 and 2, Your Lordship, for Karnataka State Board of Waqf. Direction is given to accused number 3 and 4, Your Lordship, as per the order. They have to conduct the training, CTI training in respect of the.
Who appears?
Your Lordship, in a similar matter.
My lord, in page number, item number 26, my lord, Mr. Kotwal appears for accused number 3 and 4. He is not before the honorable court. They are, my lord, they were served, my lord, they did not, my lord, file the compliance of.
Notice is not issued.
Yes, my lord, notice is issued. In both the matters, my lord, kindly peruse, my lord, 22 and 26, my lord.
Notice is. So wait.
My lords, for accused number 3 and 4, in the connected matter, my lord, my lords, humble submission, my lords. In connected matter, that is 522, my lords, for accused number 3 and 4, I have filed my wakalat in the last 2 weeks before, my lords. I need 4 weeks time to file the affidavit, my lord, please. To file the counter affidavit. In the connected matter, my lord, 522, my lords.
You want to file?
I want to file the affidavit, my lord.
File it.
Please, my lords.
My lord, in 22, may I pray the honorable court to kindly direct the learned counsel, Mr. Kotwal, to appear for 3 and 4, my lord. See, they are the same parties.
You are appearing for 3 and 4?
My lords, I have no instructions in 22, my lords. 26, I have submitted, my lords.
Find out.
Lords,
May I
please,
pray-
my lords, I will take the instructions, my lord, please.
That may kindly be noted, my lord, because your lordship considered on 18/6. This is the situation. My lord, one more submission, my lord, if your lordship permits me. There are 4 matters. In the another 2 matters, my lord, I have prayed the honorable court to recall the order. What they have done, my lord, they undertook before the honorable court that they will comply, file the complying affidavit. My lord, a totally false affidavit is filed. They did not comply. That also I have brought to your lordship's notice. Kindly, my lord. If orders are, my lord, not complied with, my lord.
Keep it on which date?
In both the matters, my lord, 22 and 26.
Advocate Mr. So appears in place time. Also took instructions that whether he will be appearing for discipline 3 and 4 in the present contempt proceedings. If learned advocate is going to appear, wakalat number shall be filed.
Please.
Within 2 weeks to be listed on 2nd September.
Please. My lord, both 26 also on 2nd September. I am much obliged.
This is bill number 23. Mr. Badrinath R.
Happy for the complaint.
That's I pray for 2 weeks' time in this matter, my lords. 2 weeks' time, my lords, sir.
Directly the page number 15. 2 weeks to learned additional government advocate promote the petition raised for time for 2 weeks, 10 or to 13th September.
Twenty-four urgent, seal number 25. Mr. K. Prasanna Shetty.
Lords, in this government order has been issued yesterday. Lords, my apologies, the translation is not. It's yesterday it has been passed. Lords, to implement the order passed by the Honorable Court and to declare the probationary and to pay the wages. All the order has been passed, my lords.
Complied with. To place on record.
Please, I'll file it
Learned
along with the affidavit.
Additional government advocate Mr. Pramod Krishnan wants to place on record. Order dated 31/7/24, which is passed, which according to her submission, complies with the directions of the Honorable. Compliance affidavit may be filed on or before next date, put up on 22nd of August
Please.
at 2:30.
26 urgent, seal number 27. Mr. K. K. Vasant.
Is my lord, with respect to non-payment of interest partner. There is a direction to pay the arrears of the salary as well as the interest partner. The accused number 1 has paid only, cleared only the rent, my lord, sorry, salary partner. So far as interest part is not been.
Notice is issued.
Notice has been issued.
Who appealed?
A1 has not been appeared, my lord.
Wait then. 21st August.
This number 28.
Appearing for the petitioners, my lord, we seek a short accommodation in this.
20 at the request of learned advocate Miss
Darshini, my lords,
Lakshmi,
PM.
PM, stand over to 20th September.
Much obliged, my lords.
Seal number 29.
Appearing for the government, my lord.
Karan Shetty.
For the petitioner, my lord.
For respondent 3 in this matter.
My lords, the
BBN.
Pardon?
I am for respondent 3 for BBN.
Let it be. Let it go to. This is that medical.
This is pertaining to the removal of the requirement of an occupancy certificate for supply of electricity, my lords. This pertains to the removal of the requirement of having an occupancy certificate for supply of electricity. There was an amendment to the conditions of service that were drafted by the Honorable KARC.
We'll consider in September, for September.
My lords, if I may make one submission, my lords, the issue in this petition pertains to unauthorized construction as a result of this amendment. My lords are already seized of a suo motu petition on that very issue. If this may be tagged with that, my lords.
That when that petition is coming up.
My lords, that petition, the next date is on 19th August. I have the date, my lord. I have the number as well as the
Give the, on that day you give.
number. 19th August is the next date, my lords.
August.
The petition number is, I'll hand it. Obliged.
To be listed on 19th August along with.
This number 30. B. Vachan.
I appear.
Yeah, Amicus, my lord, in this matter.
Respondent, my lord.
The state has filed response. my lord.
Respondent number 1 in this matter.
May I, my lord, persuade your lordships to see some of the salient, my lord, aspects forthcoming.
We'll take up this on 26th August.
My lords, your lordship may consider my request, my lords. Union of India is not a necessary party to this PIL.
Who?
Union of India, my lords, because health is a state subject.
There's the health minister in the center.
And
My lords,
health, my
that
lord,
may
the
be
National Health
so.
Mission is regulated by them.
My lords,
They have no role.
no,
The
we don't
National
have,
Health-
my lords, let me submit on my locus, my lords.
No, let
Let
them
the
file a memo
amicus
and
not
get.
become the petitioner. The amicus is only to assist the court. My lords, health is a state subject. We have already released the funds to the state. The reliefs in the petition do not concern the union. The state has rightly responded to it. We don't even have a copy of the state's objections, nor has the amicus filed any report till today. My lords, union is not a necessary party. My lords, we have nothing to say in the petition.
At their risk, my lord, if they want to get deleted, it is their choice. But my purpose of, my lord, arraying them was this. Under the National Health Mission, specific grants are released by the center.
You be here, madam, but don't take any stand. So next 26th of August.
Grateful.
Very well, my lords. My lords, your lordships may direct the amicus to circulate a report if he has filed one.
We have not filed anything. State has filed, state.
My lord, I filed a report yesterday. I gave a copy to my learned friend's colleague.
Very
She was
well.
present yesterday.
My lord, I'm sorry, my lords. I was on VC yesterday. I was not in person.
No, her colleague was present
No,
yesterday.
nobody was present, my lords. Anyway, I'll take a copy.
You can collect it, my lord. There's no big.
You can give copy.
From the state.
Very well,
I have
my
also
lords.
collected from the state only.
One more copy.
Very well, my lords. The
Very
amicus
well
is
drafted
to his
state
brief and not
response, my lord,
comment otherwise.
comprehensively filed. Great.
I'm grateful, my lord.
Obliged.
Restricted only. Declared. When? When declared? The calendar. It's not a restricted only. Only 27th.
Number 31. Vimatika Gowda.
Pray for the petitioner, my lord.
Hearing for the respondent.
I pray for a short accommodation.
My lord, it's just to consider the representation. Very well.
I pray for a short accommodation, my lord. Any date next week, my lord.
Which one?
Serial number 31, my lord.
19th September.
Oh, grateful, my lord.
Name is number 32. So Shivaldi.
I'm pray for time, my lord. Senior is not well. At the request of learned the appellant. Petitioner stand over to 23rd September.
Number 33.
Lords, I appeal for the petitioners in this environmental compensation matter, my lords. Environmental compensation, my lords, imposed by the board, my lords.
That orders are
That
awaiting.
orders are awaiting, my lords. My lords, what has happened, my lords,
Simply, you will go, all of you will go to the authority and
please, my lord.
reconsider. That
Please.
is the only thing to be done.
Please, my lords.
The authority will treat this as a notice and hear you. That is the only thing to be done.
My lords, in this case, this is second round of litigations.
In those matters.
In those matters, that is what the council considered, that they want to treat it as a show cause notice.
And,
My lords,
and all contents will be raised there.
my lords, the earlier contention, this is second round. In these petitions,
In those petitions,
those petitions.
they will treat this as so cause notice and every contention will be raised by you.
My lords, in these matters, my lords.
Not in these matter, in that matter.
Their matters. Please.
What is in this matter now?
These matters, already in 2020, my lords, the very same party has been, has preferred a writ petition, my lords, an earlier round. And there, my lords, the honorable learned council contended that they are having powers to issue, and your lordships was pleased to know, pass orders that they do not have such statutory powers. And that is observed in the earlier round of litigation, my lords. That is, I have annexed that order also along with this writ petition. Now, my lords, for clarity, your lordship.
Where is pollution control board? Not there. Wait, keep back.
Please,
Keep back, second half.
please.
33 and 34.
Next.
My lord, 34 is also covered, same aspect.
Yeah, keep it.
35. The Sarvana, yes.
I couldn't find a rejoinder. Seeking further time in this case, notes. I'm seeking some more time in this case for filing rejoinder.
At the request of learned advocate for the petitioner, stand over to 25th September.
Please, no. Interim order may be kind. Interim order.
Interim order shall continue to operate till the next week.
Number 36. The Raghavendra Gayatri.
ನಾನೇ ಹಾಕಿದೆ.
36, yes.
Promotion to the cadre from the cadres of my lord, from stenographers to senior assistant. My lord, rules of 96 as well as 2016 prescribes, my lord, 1 year working as an assistant.
This can wait, we'll take up on 3rd September.
Filed objections will not, we are supporting the case of the appellant.
And
One
submission,
my lord. Promotions are all delayed.
It's a case wherein, my lord,
Promotions can wait. 3rd September.
stenographers working in, my lord, authority, by way of, my lord, discussion and deliberation, this order was passed.
And learned single judge order, my lord, the implementations problem is there, my lord, and
Lord, I strongly oppose, my lord. We have also filed.
Lordships
We'll
can
see on-
not stay the operation.
No, I strongly oppose, my lord.
Stay the operation till then, because if the effect is given, my lord, it will, the whole process will be.
Lord, in fact, we have agreed to forego seniority and
Keep it earlier, 27th.
Please.
Yes.
But we will also negotiate with the authority, my lord, legal service.
Yes.
Please.
Number 37.
For the complainant in the connected matters, my lord.
My lordship, I'm appearing on VC. My
The matter,
camera is not working, my lord.
my lord, the matter has been seized off by the Honorable Supreme Court, wherein this Honorable Court, my lord, and it is permitted to place the copies of the order.
In this matter, my lordship, there is a POXCO case filed against the father at this point
I'm
of
making
time.
submissions about that.
And today the child is being
My lord, the Supreme Court, in fact, the Honorable Supreme Court has stated that the child would have to be medically examined again. Because the POXO, my lord, both the parties have been warring parties. The father has been given the custody even by the trial court, high court, which is confirmed by the Supreme Court. My lord, they placed the order of the Honorable Supreme Court, wherein,
What is it matter about?
my lord, there are 3 contempt petitions, my lord. One was a civil criminal suo motu contempt because of for the reason that the mother failed to hand over the custody. Therefore, we had to prefer a habeas corpus writ petition wherein this honorable court, the coordinate bench of this honorable court, passed an order stating custody has to be handed over, and also initiated civil suo motu and criminal suo motu proceedings against the mother. Then your lordships, then an earlier order wherein your lordships have in fact directed her to do community service in a hospital and gave her 6 months time to finish it. But she finishes it in 4 months and she files complaint affidavit. Now what happens is, in the meantime, your lordships passes an order in December and January stating the child should stay with the mother during the weekends. Agreed by that, the father approaches the Honorable Apex Court. The Apex Court stays both the orders, my lords. Now, the important thing is, once till date, the lady has not been given interim custody of the child for more than 10 days. When she's given the interim custody of the child for more than 10 days, she goes before the police station and she files a POXO, my lords. Now, I challenge it by way of a 482 proceedings, wherein the learned single judge has stated that based on the undertaking given by the state and the mother, that they will not take any coercive.
This order will operate, Supreme Court order.
Please, my lords, my lords may have it adjourned by 4 weeks. Please, my lords.
Lordship.
In view of, yes.
Lordship, this matter, there's a POXCO case filed against the father, and today the child is being subjected to a medical test as per the Supreme Court directions, my lord. So
We're adjourning it. in
This
lieu
could
of-
wait, my lords, is what my rest of.
by 4 weeks, I would oblige, my lord, if it's adjourned by 4
in lieu
weeks.
of
Please.
Order dated 22/7/24, passed by the Honorable Supreme Court in special leave to appeal into Writ number 19, number for special leave to appeal into Writ C, number 1092 of 2024. From IS was rightly requested by learned counsel of the parties.
My lords, page number 3, may I also
They are
request?
required to be adjourned. Stand over to
Please, please. Oblige, my lords.
21st October.
Grateful, my lords.
Permission. Next matter. Government has sought time on the last occasion to confirm their stand about the resolution, impugned resolution. If government is not ready, my lord, it could also not.
That's Additional
matter.
Advocate General is appearing in this matter. She seeks for a small accommodation, my lords.
Learned additional government advocate 6 times, stand over to 20th September.
My lord, I have a small submission, Your Honor.
Interim order operating in the.
Writ petition.
Interim order in contempt petition.
Not in the writ petition, it is there, connected writ petition.
This is 38.
29219.
Yes, my lords. My lord, I have a small submission, Your Honor.
Order operating in writ petition number 29219 of 23 shall continue to operate till the next.
Great. My lord, I have a small submission, Your Honor. My list is serial number 54. And I need only 10 minutes time to submit my, make my submission. My client has been dismissed, he retired in May 22, dismissed in July 22 with punishment for the retrospective effect from 2009, stopping his pension and medical treatment for his cancer wife. Just I got an order and they come on appeal and they don't come around to think. Kindly accommodate me in the afternoon, Your Honor, please.
So what?
I may be accommodating the year, my matter may be heard in the afternoon, Your Honor.
We'll see if time permits.
Much obliged, Your Honor.
Past four matter, list number one, seal number 6. Dr. KB Vijay Kumar, party in person. Dr. KB Vijay Kumar, party in person, seal number 6.
The learned party in person was absent in the first half. Full stop. He was again not present when the petitioner was called out for the second time in the second session. When it is going to
This matter is connected to that other writ.
10 to 29th of
Please.
This seal number 33,
Lord.
34.
Why it is kept at 2/3?
My lord, that earlier round of litigation, there was already a clear finding by this honorable court that there are no statutory powers with KSPCB to levy such an order of environmental compensation. My lords, your lordships have gone through that order, my lords, which is annexed along with the petition at Annexure C. Your lordships, peruse at page 47. Page 40, page number 47. my lords. At page 46 and 47, my lords. This is Annexure C. My lords held in para 3 that, my lords, para 3, your lordships. The demand environmental compensation. Am I getting your lordships?
But then this will follow the same fate as other.
My lords, there the board considered that they are going to treat it as a show cause notice, my lords.
Will not take in different, how can it?
My lords, this is of the year 2020, my lords. And this judgment, my lords, is followed by another judgment, my lords. There are a couple of matters. This is not one in one matter, series of matters. And in 34, my lords, it is the same party also. Is there.
Notice is issued?
Issued.
Who appears?
Board, Mr.
Rajesh Chaudhary.
Board, my lords. Mr. Chaudhary appears.
Chaudhary, where is he? Let him come, we'll take up on 13th.
My lords, meanwhile, my lords,
Meanwhile, what?
a stay of,
Then 7th, let us see, 7th.
as your lordships please, what, my lords, these are all small petty industries, my lords.
But we have taken one stand in group of the similar petitions.
My lords,
So it can't be different here. Let them come. 7th. Wait for.
until then, let them not precipitate, my lords. What happens, my lords?
Tomorrow not. 7th is not far.
Let them not
6th.
precipitate any kind of
They will
action.
not, 6th. Come, 6th.
Any date, my lords, to your lordships convince, but they are precipitating. Officers visit there, they get panicked. That's what is happening, my lords.
Let
This
us
is-
see on 6th what.
These are all of the demands of 2023.
6th.
34, my lords. 34, serial 34.
4th.
34 is also same, my lords. It is the same party also, my lords.
Both.
6th.
Seal number 56. Anil Kumar.
Please, my lord. Your lordship was pleased to hear me on the last occasion, my lord. Today, additional documents was to be produced. Lord, the complainant has taken back the entire file and I filed NOC, my lord.
So what is to be complied with here?
My lord, on Saturday, they've taken the NOC from me, my lord. Another advocate has filed wakalat on behalf of the complainant, my lord.
So you are Mr. Anil Kumar.
Please, my lord.
Learned advocate Anil Kumar stated that he no more appears
Please, my lord.
on behalf of the complainant and another learned advocate would appear. In view of these statements, stand over to 25th September.
Please.
Number 57. Ajay Kumar Patil. Arrest.
May I submit, my lord? Please, my lord, as I had submitted yesterday, three main issues, my lord, out of which two issues there is unanimity, there is absolutely no dispute at all. One is, my lord, OCI cardholders have to be treated on par with Indian citizens. First submission. That they also agree. There is no dispute. It is now covered by the judgment of the apex court in Anushka Ranguntavar's case. My lord. Second aspect of the matter is when OCIs are being treated on par with Indian citizens, they are to be considered for admission only to the general seats or the open seats, not for the reserved seats. Even I concede that issue. Both these they are following. The KEA, my lord, as well as the government, at least KEA has
Petitioner will follow the principle in Anushka. Secondly, you are conceding that he can compete only in general seats.
general seats, yes. Yes.
Not in reserved.
Not in the
Any
reserved
of the
seats
reserved
at all, not at all, not at all.
Then
Though I myself, in the sense that my father belongs to the OBC, I am not claiming any reservation because I am not a citizen of India. Now, in this general, my lord, there is a subclassification which is known as Hyderabad Karnataka general seats.
Hyderabad, Karnataka, general seats.
General seats. Now, Hyderabad Karnataka itself is the broad classification where
So how much, what is the extent of reservation?
in the educational institutions situated in the Hyderabad Karnataka region, that is the 7 districts of Karnataka which are known as Hyderabad Karnataka, 70%, 70, under clause 6 of the reservation order, is reserved for local persons.
Under clause 6.1.
6.1, as well as 7. Yesterday I had passed on that copy. Seven zero for educational institutions situated in those districts, and 8% in institutions all across Karnataka, other than those. 8%, that is clause 7.
So 70% is in
70% in those 7 districts, 6 districts.
Hyderabad, Karnataka.
Hyderabad, Karnataka region.
Region.
If I may just, if there is a medical college, let me say, my lord, in Gulbarga, Kalaburgi, or in Bidar.
And 8% in?
8%, for example, the institution is situated in Bangalore, Mysore.
In the colleges other than region.
other than this region,
Other than situated or.
other than situated in Hyderabad, all across the state, other than that area, 8%. So there, my lord, in this Hyderabad Karnataka classification, which is the broad classification under 371J, it is again further subclassified into Hyderabad Karnataka general and Hyderabad Karnataka reserved seats. If it is a reserved seat, I am not entitled to. But if it is a Hyderabad Karnataka general seat, my respectful submission is I am entitled to be considered for admission depending on my merit, according to my merit and ranking in need. If I may just point out, my lord, in that context.
This Hyderabad, Karnataka is 371J.
Yes. Yes. It is 371J. It is only a special provision considering the fact that the area is a backward area.
371J, what is the object of 371?
371J is the entire population of that area,
Correct.
not just the reserved categories, anybody. It could be an upper caste person, it could be a backward class person, it could belong to SC, ST. The whole population of that area, since the area itself is considered backward, people from that area should be given.
You are saying that because you are treated as at par.
At par.
With the other citizens.
Yes.
You automatically become entitled to 371J.
Not only that, my lord.
That is your submission.
I have studied there. I am myself, my lord, petitioner herself. She has studied there.
Studied it?
In Ballari.
When?
I have completed my second PUC just now. And my father, before going abroad, for 15 years he has studied there. He has completed his medicine also from there.
Today, both of you are overseas citizens.
Today, no, my father is still a citizen of India. He has come back. Yes,
you are a candidate.
I am an OC.
As a candidate, you are overseas citizen.
I am overseas. Candidate herself is an OCI card holder. Candidate is not a citizen of India. I'm sorry, I apologize. Then father is also, I am told,
He's
OCI.
he's a British
British citizen. I'm sorry. Father is also a British citizen, UK citizen.
He is also a British citizen.
Yes, he completed his post-graduation here from Ballari, then went to UK. He completed his further studies there, worked there for some time, took up British citizenship. That is when I was born. And he came back to India. He did not come and settle down in Bangalore or Mysore or Bombay or Delhi. He went back to his roots. He said, if I'm going back to India, I'll go back to my roots. You also come and you stay with me. You study here. Petitioner has also studied there. On facts. I have produced the certificate of the petitioner also.
According to you, Anushka is covers your case.
It covers the first aspect where I have to be treated on par with Indian citizens.
It covers totally, according to you.
Now that is my submission, yes.
Is it your argument?
Yes, yes. My argument is, as per Anushka, the minute it says you have to be considered on par with Indian citizens, then my further submission is, whatever an Indian citizen is entitled to under the general category, I am also entitled to. If a person, let us say an upper caste person from Hyderabad, Karnataka area, he will get the benefit of Hyderabad, Karnataka general. But an upper caste person here living here in Bangalore or Mysore, he will not get that seat. Because he is not a resident of Hyderabad, Karnataka area. He is not a domicile of that area. So irrespective of, in the general, everybody can compete in the general category. So consider me under the general category. There, my lord, if I may just submit, under Rule 5 of the Karnataka selection of candidates for admission to educational institutions. Rule 5, my lord, there are two conditions. One first hurdle that one has to clear is that he or she must be a citizen of India. That is the very first hurdle. Or he must have, in addition to that, being a citizen of India, they should have done their 10th or 12th standard from an educational institution.
Otherwise entitled to be considered in the Reserved categories?
I'm not claiming.
No, not claiming, no, otherwise they are, no.
No, no. So far, my lord,
Only treatment given is at par to be treated with citizens.
there is a,
And that too in general category,
yeah, two in general category.
in no other category.
It is not.
Yes.
So my respectful submission, my lord, under Rule 5, two hurdles have to be clear. One is you should be a citizen of India, and you should have either cleared your 10th or 12th standard from an educational institution situated in Karnataka and studied for a minimum of 7 academic years in Karnataka. Now, as per their own admission, what they are applying the rule to all other OCI cardholders, including me. Under Rule 5, you will be eligible for admission to all government seats because you are treated on par with Indian citizens. And you have completed your 10th and 12th standard and studied for 7 academic years in Karnataka. Now, there is a further condition for those from Karnataka who have not studied in Karnataka. Who have not studied in Karnataka, students who have not at all studied in Karnataka. The condition is, for example, my lord, somebody is posted in Delhi on an all India service or in the central government or maybe in any other force or any other bank. Then the child automatically will follow the parents. Therefore, the child would not have studied in Karnataka. Not a single academic year in Karnataka. There, my lord, the second condition is that the parents should have studied for a minimum of 7 academic years in Karnataka. Then they are entitled to be considered for seats in Karnataka. They need not have studied in Karnataka. So the first hurdle regarding citizenship and having studied, they do not fulfill. Notwithstanding the fact that they do not fulfill that condition, they are considered as domicile of Karnataka or students of Karnataka origin, and they are considered for the seats in Karnataka. Applying the same analogy, the first hurdle regarding citizenship is now they are not applying, they cannot apply it to me. So that hurdle regarding that I am not a citizen, my lord, then cannot insist upon. The second here, the rigor for Hyderabad, Karnataka is, it is not enough if you have studied for 7 years, you should have studied for 10 academic years. Now, if I satisfy that, when they are applying to all OCI, if a OCI cardholder is situated in Bangalore, studied in Bangalore, he will be considered in the general category. So my respectful submission, applying the same analogy, merely because I am an OCI cardholder, they cannot say, we will not give you, though I fulfill the second condition, which says that I should have studied for 10 academic years, or the parent should have studied for 10 academic years. So therefore, my lord, my respectful submission is, may I just pass on, my lord? This will make the picture very clear. I have filed it along with my IA also, but I am just passing on the seat matrix, if my lord permits, my lord, which was published for the academic year 23-24. This will make it very clear, though the covering letter is in this Kannada. May I request my lords to turn to annexure 4 of that seat matrix, annexure 4. My lord gets it, my lord. Annexure 4. The heading is distribution of first MBBS government seats among various special categories, both in government and private medical colleges for the academic year 23-24. HK category wise seat matrix. HK here stands for Hyderabad, Karnataka. Now kindly see a college in Bangalore, Bangalore Medical College and Research Institute. Totally there are 16 seats for Hyderabad, Karnataka. HKT total. Hyderabad, Karnataka total.
Very first.
Very first one. First column. 16. Out of which?
Very 16.
1-6 below. Serial number 1, Bangalore Medical College and Research Institute.
Annexure 4.
Annexure 4. Annexure 4.
This is also.
16 seats. My lord gets it, my lord? I'm sorry if there 7 seats. GMG, that means general merit, general. Anybody, Hyderabad, Karnataka, they fulfill, they are eligible. Now next is GMR, that stands for, I am told, GM rural. There is a rural area which is under the municipalities or depending on the population, it is that. Now, after that, my lord, the reservation comes subsequently. Your lordship will get SC general, that is the 5th column, 3 seats for SC general. These are the reserved seats. Then SC rural, no seat for SC rural, SC Kannada medium, no seat, ST general, 1 seat. So I am not asking for this SC general, SC rural, SC Karnataka or ST general seats. I am only asking in this general merit general in Hyderabad, Karnataka. The broad classification is Hyderabad, Karnataka. There is only a sub-classification, not a reserved category seat, is my respectful submission.
So that's what you are claiming is in a way sub-classification.
Classification, yes, I admit.
It is also not sub-classification. They would say that.
Subcategory, I would say.
They would say that you are a group below with which is having a different.
Yes, that is their contention. But then may I come to next page, my lord, if my lord turns to. These are up to serial number 63. Serial number 53.
What is this GMG?
GM general. General merit, general. In any person. GMG means any person. Including upper caste, lower caste, reserved category, SC, ST, OBC. It is open to everybody. There is no reservation there.
Where?
In that GMG.
GMG.
In GMG. GMG is not a reserved seat.
But GMG is one of the slot of reservation.
That's my respectful submission, my lord. It does not amount to. I'll point out with reference to certain documents how it is being treated. But may I request your lordship now to turn to serial number 54 in that.
HKT is reservation or not?
HKT. HKT total seats.
It is kind of reservation or not?
According to me, it is no.
No.
HKT, half of it may be reserved. The remaining half, 70 is not reserved. Kindly turn to serial number 54 there in that. The first one I gave an example of Bangalore. 54 is a institute which is situated in the Hyderabad, Karnataka area. 54. 54. Bidar Medical College, Bidar.
Bidar, yes.
84 seats, total 84 seats for all local persons only. Nobody from outsiders. It has to be filled by persons who are residents of the Hyderabad, Karnataka area. Out of that, general merit GMG is 29 seats. So these 29 seats are not reserved seats. They are open to everybody. Irrespective of their caste or community, you will not insist on their category certificate or SC, ST certificate or OBC certificate. If I have the merit, and this is according to merit, 29 seats. The next one, serial number 55, Gulbarga Institute of Medical Sciences, Gulbarga.
This 84 seat constitutes 70%.
70%, yes, my lords, absolutely. 84 seats constitute 70% of the intake.
So 29 seats is a part of 70%.
29 seats is part of that 84%. It is 84 seats.
Part of 70%.
Yes, a part of that 70%. Yes. Yes. Next, Gulbarga Institute of Medical Sciences, 83 seats again,
Correct.
29 seats.
Correct.
So if this seat matrix, the classification is taken into consideration, the general merit seats, my lord, is what we are entitled to. Now, may I just point out to your lordships, my lord, one aspect as to how the admissions are being made. I have produced, my lord, at annexure U, page 182. Annexure U at page 182. This is the allotment letter issued to one candidate for the previous academic year. Page 182. But first, may I request my lords to turn to annexure U1 183, because that is her application. That will give a 183.
Which page?
183. 183. Now, this is the provision admission letter in respect of one candidate. Kindly see. On the right-hand side. First, my lord, gender is female, the second column. The nationality is OCI. And the category is general. Now, on the left-hand side, remark, my lord, your lordship were kind, qualified for online choice filling process, eligible for UR. UR stands for unreserved, and URPH seats, unreserved, physically handicapped seats.
Where is that?
On the left-hand side, below the
allotment category, open PWD.
Yes. No, in 183, my lord is reading 182, my lords. Yes.
183.
182 is seat allocated category, open PWD. My lord.
We want us to read 182.
Now 182. Now may I request my lord to turn to 182.
All right.
Yes. There, category is general. Subcategory person with disability. So I may call this as a subcategory, person with disability. Yes. I am OCI. There, all India rank, choice number, seat allocated category is open PWD. In the open, though this physically handicapped, my lord, is reserved seats. Ultimately, there is a certain percentage of seats which is reserved for persons who are physically handicapped.
You're highlighting it, this is open category.
Yes.
General category.
General category. If this candidate had been...
PWD quota is general quota.
No, within that PWD quota, there are PWD open, PWD reserved.
So we are also saying that it is within that quota.
It is within that quota, but they are being considered and allotted seats only in the general category. That is my submission. That is what I want to point out, my lord. Yes, that is also a category, a quota. PWD is a separate quota. In that quota, there are seats reserved for general candidates, seats reserved for reserved candidates. But for the general seats, notwithstanding the fact that the candidate is an OCI card holder, she was considered and allotted the seat under the open category PWD. Now, PWD is a category. Hyderabad, Karnataka is a category. In PWD, open seats, they are entitled to OCI card holders. In Hyderabad, Karnataka, my respectful submission is they are entitled to for the open seats. And this has just previous academic year. She has been allotted a seat very much in Ballari itself. Vijayanagar Institute of Medical Sciences, she has got a seat there. Kindly see in the All India quota. Vijayanagar Institute of Medical Sciences, Ballari, she has been allotted a seat. So there is no bar. Or on the other hand, OCI card holders are being considered for all general seats all over the country. Now, this Hyderabad, Karnataka is a peculiar situation which is there in Karnataka. So there is no reason why OCI card holders should not be considered under the open category in Hyderabad. May I just request my lords to turn to page 184 now. Page 184. At page 190, this comes under the heading reservation of seats at page 189. These are again in the premier institutes of Indian Institute of Technology in all the IITs situated in India. Page 189, in the middle, column number 3 or paragraph number 3, reservation of seats. There at page 190, the first, second, third, fourth bullet point, persons with disability.
So what is this? Part of what?
Part of the joint entrance examination information brochure for the academic year 23-24. JEE, that you, my lords, will get it at page 184. The heading.
Information brochure.
Information brochure.
So which page you are going?
May I request my lords to first turn to page 189. With the heading in the center, my lord, is
yes.
At the center, page 189, paragraph number 3, reservation of seats. It says. Now, coming to page 190, my lord, in the center, the bullet point, persons with disability, PWD, with at least 40% impairment, 5% seats. This is the reservation everywhere. Even in Karnataka, my lord, they have to follow this. 5% seats in each of open, general EWS, OBC, NCL, SC, and ST.
This 5% is getting increased now.
My lords?
5% reservation for
The
PW.
last year it was 5%. This year, my lord, I am not very
It
sure.
is increased.
It must have.
It is increased to
It
what?
has.
7% if I remember.
7%. You are right.
Last year it was 23 by an amendment probably, my lord.
Yes, so this
Now,
is
here what I want to point out, how persons with disability with at least 40%, 5% seats in each of, kindly note this word, my lord, emphasis on each of, open, 5%. If there are 100 open seats, 5 seats are reserved for PWD. Then general EWS, OBC, NCL, SC and ST. So again, if there are 50 reserved seat SC, 7% of that will be SCs with the physical disability. And if there are 50 or 100 general seats, 5% of that is reserved for general category, persons with disability or with other persons, anybody else. Even a SC can come and compete under general. A general can't go and compete under SC. So here, similarly, the analogy that I'm drawing, Hyderabad, Karnataka, general. In Karnataka, in addition, they have carved out in general, there is a Kannada medium category. Supposing somebody has studied in Kannada medium, there is a seat reserved for them also. He may be in the general category. There may be a scheduled caste candidate who has studied in Kannada medium. There is a girl reservation also. Kannada, rural, girl. So, this, my lord, and what they call it, my lord, is They call it as subcategory, PWD subcategory. And there, my lord, seats are open to OCIs also. Kindly see page 192. Six point two, my lords get it, my lord, 6.2 at page 192. OCI, the heading itself is OCI stroke PIO candidate 6.2. As per the decision dated February 3, 2023, passed by the Honorable Supreme Court of India and writ petition civil number so and so, the OCI PIO candidates shall be considered as Indian nationals. OCI PIO candidates who have studied or studying in India abroad at 10+2 level or equivalent at the time of registering for JEE Advanced are not required to write JEE and may register for JEE Advanced.
891 is Anushka.
Anushka, yes, yes. 891 is Anushka.
Yes.
Next, my lord, page 193, the second paragraph. At the time of seat allocation, kindly see this is OCI PIO candidates shall be considered for the seats in the open category. The OCI PIO candidates shall be included in the common rank list and or common rank list of persons with disability. OCI PIO candidates list as also for the female supernumerary seats. In every institution, 15% of the seats, in order to encourage gender imbalance in these institutions, 15% seats are reserved for girls, supernumerary seats. So OCI PIO will be included in the common rank list, 1. And if there is an OCI who is a person with disability, he will be included in the common rank list of persons with disability. And if the OCI card holder is a girl, she will be included or considered for the supernumerary seats also.
So person with disability in OCI.
Yes.
Will be treated in general.
In general. In
Right?
general. Yes.
That is your submission.
That is my.
And if there is a lady candidate in OCI.
Yes.
She will be entitled to supernumerary.
Supernumerary seats if it is available.
Available.
If it is available.
So therefore, equated to be.
Precisely. Precisely. Absolute. That is my. That is. Kindly now let us go back to page 191, my lord. Page 191, because this is only clarifying. Clause 5, supernumerary seats for female candidates at page 191, bottom. Supernumerary seats for female candidates. It explicitly says so. Following the directions of the Ministry of Education, Government of India, and the decision taken by the IIT Council, supernumerary seats have been created for female candidates for improving the gender balance in the undergraduate programs in IITs. These supernumerary seats will be offered to only those female candidates, Indian nationals and OCI PIO candidates. So tomorrow, I am a girl candidate. I appear for this IIT JEE. Merely because I am not a citizen of India does not make me ineligible for the female supernumerary seats. It is reserved for Indian. The minute you say they have to be treated on par with Indian citizens, they have to be included there, but only for the general seats. This is my respectful submission. Now, kindly see the next one, my lord, at annexure, page 194. This is uniformly. Everywhere it is being followed. Page 194 is the, what is known as undergraduate common entrance examination for design in IITs, for design program, UCCED, undergraduate common entrance exam for design and Bachelor of Design program. May I request your lordship to kindly turn to page 199. Page 1. May I read, my lord? All candidates must ensure that they possess valid and updated certificates at the time of applying for admission to any of these programs. Scheduled caste 15%, scheduled tribe 7.5. Candidates belonging to the creamy layer of OBC are not entitled to reservation. Such candidates are treated as belonging to the open. The benefit of reservation will be given only to those castes and tribes that are mentioned in the respective central list of corresponding states published by the Government of India. PWD candidates, here again it mentions 5% because that was
Where you are reading?
page 199, my lord, 199.
199 OCPIO candidate.
Yes, above that, there also I am below, I am coming to that also. But first I wanted to point out these PWD candidates, 5% reservation for PWD candidates, which will be horizontal candidates with benchmark disabilities as per RPWD Act 2016 are eligible for reservation in this category. Below that, now my lord has seen OCI and PIO candidates. At the time of seat allocation, the OCI PIO candidates will be considered for the seats in the open category as per the judgment passed by the Honorable Supreme Court of India with respect to the writ petition number so and so dated February. The OCI PIO candidates will be included in the common rank list and or CRL here stands for common rank list, PWD list, which is a reservation even according to them. CRL PWD list as applicable subject to qualifying in the examination. Then again, it is clarified. The last sentence is important, my lord. There, the OCI PIO candidates are not entitled to the benefit of reservation under the general EWS, OBC NCL, SC or ST categories for the allocation of seats. So they have made it clear that OCI candidates are not eligible at all. Even the upper caste, general EWS, economically weaker sections, there also they have disentitlements. So, in respect of, and when I filed the writ petition, my lord, those documents had not yet been published because the NEET controversy was going on. AIMS conducts a separate test for admission to all the AIMS. They don't come under NEET. They have their own entrance examination. There are, I am told at present, about 14 AIMS, my lord, including AIMS Delhi. OCI, PIO candidates are there also are being considered under the PWD list. And if there is a female supernumerary seat available, the OCI card holders are being considered there. Also, AIMS is an undergraduate program for medical sciences. So, for AIMS itself, in 100%, all the seats, naturally, my lord, when it comes to an all India test, there cannot be something called as Hyderabad, Karnataka. Therefore, I am not able to draw a parallel with respect to exactly or with reference to Hyderabad, Karnataka. But I am drawing this parallel with reference to persons with disability and the female supernumerary category. Post-graduation in Chandigarh and Jipmer in Puducherry. These are post-graduation institutes. There also, my lord, OCI card holders are being considered for the open PWD, open female supernumerary.
So that is all.
That is my submission, my lord. But if I may just point out how it has to be done, how the other states are treating, that is one other aspect, if my lord permits, my lord. Just annexure, one annexure or two annexures, if I may be permitted to read in the annexure R, is at page 171. This is issued by the government of Tamil Nadu after the Supreme Court judgment.
Page 171.
171 annexure R. This is the amendment that they have carried out, which Karnataka has so far not done, and this is resulting in all this confusion.
What is the amendment?
Amendment for the existing clause 7 of the government order dated so and so, department dated 26/6/2023.
Amendment in what? Some government circular?
A government order. GO is government order of the Tamil Nadu government. Amendment to that.
Tamil Nadu government.
Tamil Nadu. Yes, Tamil Nadu.
Why, how it is relevant?
This is because how they have treated the OCI card holders by means of an amendment. Earlier, my lord, general eligibility criteria, it was only A. Candidate should be a citizen of India.
Read it. Overseas citizens.
Overseas citizen of India, persons with Indian origin who are registered under Section 7A of the Citizenship Act so and so are eligible for admission in MBBS, BDS degree courses subject to the production of such registration. However, OCI PIO candidates will not be eligible for any kind of reservation and will be treated only as open category as per the orders of the Honorable Supreme Court.
So it is
Now,
clear.
yes, very clear. That is exactly what I'm saying. Open, any open seat.
So it is clear against you or in your favor?
It is in my favor. According to me, it is in my favor. According to me, it is in my favor. Why, my lord, is there in Tamil Nadu, there is no such thing as further regional representation.
Now we have understood your argument.
Yes,
Anything further?
yes. And one Andhra Pradesh also. Andhra Pradesh and Telangana. Same, identical.
Where is that?
That is annexure as next page. Next page. Page 172. This is the government of Telangana. At page 173, I am reading, my lord. In clause A, after the words Indian nationals, the following shall be added, namely, persons of Indian origin, overseas citizen of India cardholders are included in the definition of citizen, Indian nationals. Similarly, government of Andhra Pradesh. Why I am pointing out this, my lord, is in Karnataka.
Now let us go to Anushka.
Let us go to Anushka. Paragraph 54 onwards. Only 3 or 4 paragraphs. Paragraph 54 is at page 164. We note that it is not retrospective in as much as it does not affect the OCI cardholders who have participated in the selection process, having secured a seat and are either undergoing or completed the MBBS course or such other professional course. However, it will act as retroactive action to deny the right to persons who had such right, which is not sustainable to that extent. The goalpost is shifted when the game is about to be over. Hence, we are of the view that the retroactive operation resulting in retrospective consequences should be set aside and such adverse consequences is to be avoided. Therefore, paragraph 55, therefore, in the factual background of the issue involved, to sum up, it will have to be held that though the impugned notification dated 4/3/2021 is based on a policy and in exercise of the statutory power of a sovereign state, the provisions as contained therein shall apply prospectively only to persons who are born in a foreign country subsequent to 4/3/2021. Contained therein shall apply prospectively only to persons who are born in a foreign country subsequent to 4/3/2021, that is the date of the notification, and who seek for a registration as OCI cardholder from that date, since at that juncture the parents would have a choice to either seek for citizenship by descent or to continue as a foreigner in the background of the subsisting policy of the sovereign state. This is what applies, my lord, because I was born prior to 4/3/2021. I was born in the year 2006. And my OCI card has been issued to me in the year 2012. So therefore, I have produced the OCI card also. So this paragraph is what squarely applies. May I read paragraph 56 also, my lord? My lord permits, may I read paragraph 56 also? 56. Of the Anushka's judgment. I read 54 and 55. 56 at page 165. In the light of the above, page 165. Paragraph 56. In the light of the above, it is held that the respondent number 1, in furtherance of the policy of the sovereign state, has the power to pass appropriate notifications as contemplated in Section 7B1 of the Citizenship Act 1955 to confer or alter the rights as provided for therein. However, when a conferred right is withdrawn, modified, or altered, the process leading thereto should demonstrate application of mind, nexus to the object of such withdrawal or modification, and any such decision should be free of arbitrariness. In that background, the impugned notification dated 4/3/21, though competent under Section 7B1 of the Act 1955, suffers from the vice of non-application of mind, and despite being prospective is in fact retroactive, taking away the rights which were conferred also as a matter of policy of the sovereign state. Hence, the notification, paragraph 57, hence the notification being sustainable prospectively, we hereby declare that the impugned portion of the notification, which provides for supersession of the notifications dated 11/4/2005, 5/1/2007, and 5/1/2009 under the
What is
clause
4/3/21 notification?
that I have produced, my lord, in the writ petition at annexure.
Your Lordship, take page 115, my lord. Called out.
That is in judgment, but I have produced the notification itself.
Itself is called.
115.
5 of the judgment, that notification has been called out. 115. Ministry of Home Affairs notification, New Delhi, the 4th March 2021. In exercise of the powers conferred by the subsection 1 of Section 7B of the Citizenship Act 1955, and in supersession of the notification of the Government of India in the Ministry of Home Affairs dated so and 11/4, and the notifications of the Government of India in the erstwhile Ministry of Overseas Indian Affairs, published in the official gazette dated 5th January 2007.
Which is relevant?
Clause 4.
Clause 4(2).
Clause 4.
4,
Clause 4.
4(2).
116.
Clause 4 is at page 116,
Clause
parity.
4(2).
There,
Parity with non-resident Indians.
yes,
The
that
matter
is 4.
Matter
Below
of-
that, 2, appearing for the All India entrance test, such as the National Eligibility cum entrance test, joint entrance examination, mains, joint entrance examination advance, or such other test to make them eligible for admission only against any non-resident Indian seat or any supernumerary seat. This was challenged in Anushka's case. Provided that the OCI cardholder shall not be eligible for admission against any seat reserved exclusively for Indian citizens. Now, Supreme Court said, treat them on par with Indian citizens. That is why Tamil Nadu has amended, Telangana has amended,
And the explanation also.
and Andhra Pradesh has also amended. All this entire notification will not apply to me.
So they are not treated at par with the Indian citizens.
By this notification, they are not.
No,
By this notification, they are not.
only benefit carved out or mentioned is granted.
My lords,
It is wrong to say that Anushka lays down a proposition that OCI citizens are belonging to same class as Indian citizens. It is
That-
not so.
according to me, my lord, my respectful submission, that is how it has been understood throughout by
Only
everybody.
There is a conferment in terms of clause 4(2),
My lords, there is a conferment.
conferment of benefit.
Yeah, no, clause 4(2).
Conferment of benefit as contemplated in notification 4/3/21, clause 4(2).
Yes, that does not apply to us.
That
That-
doesn't make a single class of
No,
citizens.
that was how we were being, may I
There is a
clarify
very,
that
very-
aspect?
Very fine distinction.
Please, my lords.
You are given a benefit
Yes,
which is available to one of the class.
yes.
Does not make you a member of that class.
When it says at par, my respectful submission is, at
par-
par, I merge with that class.
Merging is not there.
My respectful submission is, my lord, that is what was
That is-
submitted by the central
We'll
government.
ask them.
Please,
This
please,
is
my lords.
asking- we are
According,
asking
according to me, the difficulty is, my lord, while going through the notification, my lord, it gives an impression that.
So-
But when the entire notification is held to be inapplicable, so the judgment has to be read, dehorse this notification.
Unless
It-
there is a statement in Anushka,
Yes,
statement of law,
yes.
that OCI belongs to the same class of persons as Indian citizen. Is there any such statement?
According to me, they may not be, but they have said they are entitled to be treated what was the benefit that was being given to them earlier.
Exactly.
May I request your lordship to kindly turn to paragraph 27 of that judgment, 26 and yeah. Paragraph 22 onwards. This may clarify more. This lays down what was the law which existed prior to the notification. There was a particular law which was there prior to the notification. So what flows from the notifications which were there earlier, and that is also covered by a division bench judgment of this honorable court. I'll come to that aspect, my lord, as to how we are to be treated, because the division bench says, interpreting the earlier notifications, that they have to be treated on par with Indian citizens as Indian citizens. I'll pass on. I'm yet to come to that, but here, my lord, paragraph 22. Paragraph 22, may I read, my lord, if my lord permits, because that sums up the law which was prevalent earlier to the notification. And that law has been clarified by the division benches of this honorable court, page 118.
Yes.
Paragraph 22. A perusal of the notification dated 4/3/2021 would ex facie indicate that the rights bestowed thereunder on the OCI cardholders are in fact a consolidation of the rights which had been bestowed through the notification dated 11/4/2005, 5/11 and 5/1/2009. However, the impugned portion of the notification is the portion which has been emphasized, that is the proviso to clause 4(2) and explanation 1 thereto, and limiting the parity only to NRI seats and supernumerary seats. Though through the impugned portion of the notification, the parity which existed with non-resident Indians, including in the field of education, has been modified to indicate the eligibility for admission only against any non-resident Indian seat or any supernumerary seat. It is relevant to take note herein that the non-resident Indians, apart from the seats reserved only for non-resident, are also entitled to participate in the selection process for allotment seats along with the Indian citizens for the remaining seats as well, which benefit was hitherto available to OCI cardholders by virtue of their parity with NRIs. This was the settled legal position earlier. However, by presently specifying that the OCI cardholders would be eligible for only the non-resident Indian seat or any supernumerary seat, the right available to the OCI cardholders is only for the seats which are reserved as NRI quota seats, for which they would have to compete with the NRI candidates for the limited number of seats, for which higher fee structure is also fixed. The proviso thereto makes it clear that the OCI cardholders shall not be eligible for admission against any reserved seat exclusively for Indian citizens. The provision contained in the impugned portion of the notification dated 4/3/2021 would indicate that the OCI cardholders, even if they have settled down in India and have undergone their entire educational course in India, but not having renounced the citizenship of a foreign country and not having acquired the citizenship of India, will now be denied the opportunity of securing a medical seat in the general pool of Indian citizens, including NRIs, and will have to compete only for the limited seats available under the NRI quota, which would be denial of an opportunity of education to such OCI cardholders, which was hitherto available. It is in that view contended. Now, let us go to what was the law declared by this division bench of this honorable court prior to this date, notification. May I pass on the division bench judgment of this honorable court, my lord, which was challenged before this court and dismissed. My lord permits, my lord, the division bench judgment of this honorable, wherein the law which prevailed earlier and how OCI cardholders have to be treated on par with Indian citizens has been laid down there. May I read from at paragraph 75 in that judgment. Page 116 of the judgment. Paragraph 75. Paragraph 75. This settles the issue. Hence, may I read, my lord? My lord gets it, paragraph 75. Hence, on a conjoint reading of the aforesaid provisions, it is held that the amendment made to section 2(1)(n) of the 2006 Act, which is a state amendment with effect from 24/2009, is under entry 25 of list 3 of the 7th schedule of the Constitution. This amendment was made by the state legislature after the issuance of the Notification and Citizenship Act, a parliamentary law dated 5/1/2010-9. This notification covered us prior to this central government note 5/1/2009. This notification is issued under section 7B of the Citizenship Act, which is a central law, but is regarding the rights of OCA cardholders, including their right to admission in professional colleges in the country. The state law is made under entry 25 of the 233. Under the amendment to the state law, that is 2006 Act, non-resident Indians and OCA cardholders are treated on par. But central notification dated 5/1/2000 makes a distinction between the two categories. Hence, the central law would prevail over the state amendment when viewed from the point of Article 246(1) of the Constitution. Also, if the amendment to 2000 Act is looked at from the angle of entry 25 of list 3, then it would be hit by Article 254 of the Constitution, as the rights conferred on OCA cardholders from the point of view of their educational rights is touched upon in section 7B of the Citizenship Act, impose issuance of a notification on educational rights of OCA cardholders, and hence it must be held to be repugnant. So it has already, whatever the state was doing has already been held to be repugnant. Held to be repugnant. Hence, notification dated 5/1/2009 would prevail over the state law. This is in addition to the interpretation made by the learned single judge, which we affirm. Hence, inclusion of the expression OCA cardholder in the definition of non-resident Indian under section 2(1)(n) of the 2010 Act, being contrary to notification dated 5/1/2009, is held to be repugnant and has to yield to the central law. Such an interpretation becomes clearer in view of the parity with Indian citizens. Now, my lord, coming to the directions that have been issued. Paragraph 80 onwards. At page 120 of that judgment, paragraph 80. Paragraph 80. Thus, when the parity between the OCA cardholder and non-resident Indian is removed, the concept of OCA cardholder cannot be given a restricted meaning as non-resident Indian so as to restrict such admission only to non-resident Indian quota in the state quota seats and not in the institutional quota or government quota seats under the NEET scheme. Therefore, we are of the view that the learned single judge was justified in interpreting notification dated so and so, prevailing over the state law, whether 2006 Act or 2006 rules. Therefore, we find no merit in the writ appeal. Hence, it is dismissed. Writ appeal was by the government. Now, the directions, my lord. This is most important. This crystallizes and it clearly states what the rights of the OCA cardholders were there. In view of the aforesaid discussion, we find merit in the writ petitions. Hence, the writ petitions filed by the petitioners are allowed in the following terms. Paragraph 1, the 2 and all may not be relevant. Paragraph 3 onwards. The writ of mandamus issued by the learned single judge directing the respondent state and the respondent Karnataka examinations to permit the petitioners as per their choice to register for 2019 as per the notification dated 3/1 issued by the respondent Karnataka examination is confirmed. Further, the aforesaid authority is directed to permit their participation in the ensuing counseling of CET 2020 or subsequent years for selection and allotment of seats in BE, BTech, BR or such other professional courses in government colleges, private, aided, unaided colleges, educational institutions for the academic year 2019-20 on the basis of their relative merit and ranking in the subsequent years. Now, the next direction concerns the medical courses. Insofar MBBS, BDS courses are concerned, NEET scheme shall apply for the academic years 1920 as well as 2020, and a writ of mandamus is issued directing the respondent state and respondent Karnataka examination to permit the petitioners and similarly situated candidates, that is OCA cardholders, to register and to participate in the ensuing counseling being held for selection and allotment of seats for the academic years 2021 and subsequent on the basis of their relative merit and ranking.
Now this is what? This is not Anushka. This is Pranav Bajpayee.
Yes, Pranav Bajpayee versus State of Karnataka. That was the writ petition, the appeal. This is the writ petition.
So both had a different cause of action.
There, my lord, this notification which we just read out had not yet been issued.
This notification had not.
Not yet been
then.
issued.
So that is based on earlier notification,
So which notification? Fourth,
2009.
2009 notification.
which is that?
That, my lord, also is extracted in the judgment of the Supreme
The
Court.
judgment.
It is there at page 115.
So this division bench judgment refers to 2009.
9 notification.
9, yes, refers to the 2000.
That 4-3 was issued.
Yes, 21, 4321 also.
4-3. So in that light, the Supreme Court.
Yes, because
In that light.
4321 supersedes.
Because
earlier.
2009 notification was superseded by the 4/3/2021 notification. Now Supreme Court was interpreting only 4/3/2021 notification. While so interpreting, while upholding, they said whatever was available to them before 4/3/2021 cannot be denied to them. That would be denying equal opportunity and changing the goalpost when the last stage has come. A child born in 2006 is now eligible in 2024, 18 years of old. Now in 2021 or 22, you issue the notification. When the child is in 10th standard or 11th standard, you are shifting the goalpost and saying you are not at all eligible. That is impermissible. That is what is meant by retroactive application. Though it is not retrospective, it has retroactive application. That is impermissible. So then we fall back, my lord, on what was the legal position prior to 4/3/2021. This is the legal position laid down by the division bench, interpreting this very notification of the central government. That notification, my lord, your lordship gets it, may I read that 2009 notification, which has been interpreted by the division bench of this honorable court. All the notifications have been extracted in the judgment of the Supreme Court. Kindly turn to page 113. The 2009 notification is extracted. And this was the subject matter of interpretation before the division bench of this honor. State law was held to be repugnant. The field is occupied by central legislation. You have to treat them on par with Indian citizens. Ministry of Overseas Indian Affairs notification, New Delhi, the 5th of January 2009. In exercise of the powers conferred by subsection 1 of section 7B of the Citizenship Act 1955, and in continuation of the notification of the Government of India dated 11th April 2005, and in the Ministry of Overseas Affairs dated 6th January 2007, the central government hereby specifies the following rights to which the persons registered as the overseas citizen of India under section 7A of the said Act shall be entitled, namely, parity with non-resident Indian in respect of their second one, pursuing the this, and the B, to appear for the All India pre-medical test or such other test to make them eligible for admission in pursuance of the provisions contained in the relevant acts. There, my lord, it is very clear. They had parity with Indian citizens. Next paragraph, my lord, if my lord sees paragraph 19, through the said notification dated 5/1/2009, the OCI cardholders were given the right to pursue the professions indicated therein in India and also to appear for the All India pre-medical test or such other test to make them eligible for admission in pursuance of the provisions contained in the relevant act. Since NRIs had parity with Indian citizens in that regard, the same benefit became extended to the OCI cardholders, including the petitioners herein. So Supreme Court has clearly laid down here parity.
So then what is the 4/3/21? What is the difference?
That took away this. That took away all this.
What is the difference between this 2009 and 4/3/21?
2009 said parity interpretation by means of the judgments also that there is, and that is how we were being treated. 2021 said you will be a foreign national and you are entitled to only NRI seats or supernumerary seats, and
Probably this 4/3/21 clarified.
Yes.
OCI persons will not be eligible for admission against.
The reason for clarification is
the reserved class of Reserved for exclusively citizens.
For Indian citizens, for Indian citizens.
That is the difference.
That is the difference. That is the difference.
So that's a material difference.
That is the material difference, but it does not apply to us now. So we have to fall back necessarily. When the Supreme Court said it does not apply to me. So our cases have to be considered dehorse the 21 notification as per the law laid down by the apex court as to what we were entitled to prior to that date. That is a very material difference. That is why we all went to court. Very, very material difference.
That is all.
That is all, my lord. I would, that's the judgment of the division bench judgment is, my lord. One factual aspect, the state government took this judgment in appeal to the Supreme Court, which came to be dismissed. So the judgment of the division bench has been confirmed by the apex court also. They say it has been dismissed as withdrawn because of the 4/3/2021 notification. When the matter was pending, my lord, central government issued the 4/3/2021 notification. They said 4/3/2021 notification will now apply. Therefore, we are withdrawing the SLP. Now, the 4/3/2021, when it came to be challenged, my lord, this is what the apex court. So we cannot go by the 4/3/2021 notification at all. The difficulty, if I may so, arises here, my lord, unlike in the case of Tamil Nadu, why I read out that, my lord, is no similar amendment has been carried out by the state of Karnataka to bring it in consonance with the apex court judgment. So the first condition, the first hurdle where we fail throughout everywhere, whether it is the last year OCA card holders or this year for the, you must be a citizen of India. Now, what is it that they are insisting in this?
This is also for MBBS.
My lord?
All seats.
All seats, all seats, all seats.
So you want to participate in the counseling and etc.
I only want to be considered. I am not asking for admission. According to I have a ranking of 30,000. I have produced my NEET scorecard also. My ranking as on today, because it was published just last month, my ranking is 30,000. According to my merit, consider me under the Hyderabad, Karnataka general quota. There may be somebody who has higher rank for me from the same area who is a citizen of India. I will not be denying a citizen of India the seat that he or she would be otherwise entitled.
What is the stage of process of admission?
We have not yet, only counseling also not started, and option entry, my lord, in a day or two we are releasing, because central government, all India counseling has to get over.
All India counseling.
Counseling.
When it will go?
It has already been
Now it's
notified.
started. Now
Option entry has started. All India was notified on 30th of July. Option entry is going on.
It will go on for
Till the 5th of August, option entry.
5th of.
Thereafter, mock allotment, my lord, is done. Then the actual allotment starts from the 11th or 12th of August for the all India quota and gets over.
Thereafter, we will start our process. And registration, my lord, I think in a day or two they will
It
start.
will take at least one month.
No, it may be over in the next 15 to 20 days. Not
Because
the
after
way
that,
it's
they'll
just-
start their second round. After that, we have to start our second round. That's how it's going on.
Here, my lord, what happens? Everything is online. Rupees per year. In a private college, it is around 1,21,000 rupees per year. In the first round of counseling itself, which is likely to commence immediately after the 15th or the 16th of August, 95% of these government seats will be filled up in a day or two. So, therefore, my lord, even if there is an interim, assuming, my lord, I would assume that the writ petition is allowed or an interim order is issued. My name has already been blacklisted there as an OCI, and Hyderabad, Karnataka is completely blocked to me. The procedure would be such, my lord, when an Indian citizen opens the website or web portal of the KEA, and if he has already produced his Hyderabad, Karnataka certificate at the time of document verification, which is already over. So only those who have successfully produced these documents, there will be allowed to, or depending on the region, they will be only shown this Hyderabad, Karnataka seats, and they will make the option entry. Now, as far as I am concerned, since my name is not there in that at all, already blacklisted, there is certain back-end operations which may take about a week or 10 days. assuming that there is an order. If there is no order, I don't get the seat. But in the event of there being an order, my lord, there is some technical procedures which have to be followed before by the KEA, and it is not automatic. I have to go there, I'm speaking from experience over last year or this, my lord. Whenever an interim order is passed or the final order is passed, as was by Justice Nagaratna in this matter as she then was, it took about 10 days. We had to go to there, all the candidates had to go there, back end, my lord, with the order copy. The code is known only to the KEA director and to the medical education secretary. Both have to authorize the back end operator to do it manually. Only then it will open. Therefore, there is some urgency and difficulty there.
We are hearing.
Thank
You will respond today or Monday? Monday would be. Monday. Because some other matter is in the middle of the hearing, they are waiting. So you have to answer what they are saying this.
Yes.
That they as a OCI are considered entitled to a benefit in the field of education at par with Indian citizens. So therefore, they extend their logic that whatever benefit is available to the class of Indian citizens will be by necessary implication will be available to them. And once they are equated with the class of citizens, by deeming fiction, all benefits will extend.
Will follow, will flow. That's what.
Maybe limited to the education.
Yes.
That you have to answer. And that is how they equate themselves
As
with
it
one
is.
class for the purpose of education, admission benefit
Yes.
with citizens. So
Further
even if-
limitation is only for open seats.
Even if they are not merging with the citizens, they are entitled to all
benefits
all-
of.
So that you have to answer.
Name a lot, they are broadly in agreement with the fact that they are not entitled for any reservation.
Yes.
They are in agreement with the fact that they are not entitled for any
So you
reservation.
elaborate your argument. Not just in one line.
Yeah.
Yes.
Pledge.
We'll continue Monday.
Please, my lords.
Monday in this afternoon.
There are two other matters in list number 2, which were being posted along with this matter. They are slightly different, my lord. All that I can say is they can either be disposed of if the learned there,
Monday
or
will-
let it be called on Monday along with this matter.
I have not seen it, how it.
Please,
is to be
please,
done.
let it be
Mon-
called on Monday along with those matters.
Monday will do.
In list number 2,
Yes.
there are 2 matters.
So they are,
One.
I think they are conceding in same. Conceding means they are saying.
In fact, there again, there is an interim order passed by my lords. We have gone and showed them the interim order.
But
They
on
are-
Monday will.
Monday, we'll see it on Monday. Oblige.
One small submissions in this.
You are appearing, madam, for?
Central government,
Central-
Union of India. Union of India.
Union of India respondent
Is your-
4 in this
What's your
case.
good name?
Swati Pandurang. My lord, in this case, the FRR wants to make some submissions.
Who?
FRR, Foreign Regional Registration Office, who is present before this honorable court.
We don't permit any party in person. In that way.
Okay, I
Out
can take,
of question. This is
can I
the,
take the guidance?
this is the court of lawyers, not party in person.
True, true. I
So
agree.
nobody will be in that way. This is not a public platform.
I'll take the
Don't make
instructions.
such request.
No, I'll take their instructions.
No. Nobody will be permitted except lawyers. If they want to engage a lawyer and come by way of becoming party, they are welcome. This is not a public platform to permit anybody can be addressed in the controversy.
I apologize. Ma'am.
Yes. Don't make such request before this court, at least.
This is number 58. Sir, Vakund, Komati.
Thank you. ಒಂದು ನಿಮಿಷ.
We'll continue this up to 4:40.
4:40, my lord. I'll be here.
4:40. There is one or two matter. to-
Very well.
Yes.
I'll be.
No, Mr.
Then
We'll continue up to 4:40.
till 4:40.
Oh, till 4:40, my lord. I'm sorry. We thought, my lord, your lordship, sir, take it at 4:40, my lord. My apologies, my lord. My profound apologies. And I must also apologize to your lordship, my lord, for being absent. Yes, my lord, I was here.
No,
Suddenly I was called out, my lord. I thought, my lord, other matter will go on.
doesn't.
My lord, I'm so sorry. My lord, I'll not take more than, my lord.
Your colleague has
20
made
minutes.
complaint of us.
No, my lord. No, my lord. It was called out. And my lord, he said that I was not here.
This is on
Therefore,
light-
I had to apologize.
Lighter when, don't take it seriously.
No, even otherwise, my lord, when I'm not here, when the case is called, I must apologize. So it's not fair, my lord. We have to be here.
Yes.
That's all, my
Let
lord.
us
that I-
now.
My lord,
this
I had given to your lordship, my lord, one list of dates.
List of,
Dates, my lord, list of dates and synopsis submitted on behalf of respondent number 4.
where is the other?
My lord, if it is not there, I'll give you one more. Minute.
No, it was there yesterday. Yes, it is.
Listed out, my lord, chronologically, my lord, what had happened. That's all, my lord. I had listed out various, my lord, dates which are relevant and which have some bearing, my lord, on the, till, my lord, page 4. He would have already, my lord, submitted all this. But what is more important, my lord, is please come to, my lord, running page 3. Lord, serial number 10. Rajamma, my lord, and 5 others filed a writ petition.
Now this challenge was after how many years?
This challenge, my lord, was after, my lord, 70 years, my lord. That first one, 2009, was, my lord, after 70 years. Now, my lord, we have already crossed, my lord, another 14 years. So today, their virtual challenge is after 84 years.
2009 was a petition by one Ramdas. Who
Yes,
was
my lord,
Ram-
that was after 70 years.
That was after 70 years.
Yes, that's what, my lord, the learned, my lord, this honorable court also observes that it is filed after 70 years. Therefore, I'm dismissing it.
So first challenge was after 70.
70 years.
Yes.
My lord, can I persuade your lordship, just look at, my lord, that order itself, my lord, since my lords asked me this, at page 619, my lord, volume 3, if your lordships have.
Six zero nine.
619, my lord.
619.
619. In my list of dates, my lord, I have set out, my lord, which page, what is the annexure. If my lords come to page, my lord, 623. Sorry, 622, last paragraph, my lord, 622. It starts at 619, at 622, second, my lord, last paragraph. By perusing the averments made in the writ petition, it is clear. Petitioners practically question the acquisition notifications. My lord, so is the question here, my lord, I'll point out. The preliminary notifications issued way back on 24/6/38, that is about 70 years prior to this date. According to the petitioners, they have not handed over possession of the property and they continue to be in possession of the property and therefore acquisition notifications have lapsed.
contention of the petitioners cannot be accepted. Fourth respondent, who is the beneficiary under the acquisition, had approached this court in WP 5271 of 1995, and certain of the petitioners were also parties in the said petition. After hearing the writ petition was disposed of by this court on 6th of January by observing thus. That is, my lord, the fourth respondent before my lords now, that Mysore, my lord, Stoneware. Annexure 8 and D proceedings of the then government of Mysore, dated 15/3/1978 and 22/2/1937, make it very clear that the lands in survey number 79 and 90 of Chikkabanavara village, apart from other lands in the neighborhood, in all measuring 118 acres 21 guntas, were proposed for acquisition for the use by the petitioner company. Annexure C, the extract of the record of rights would reveal Kata was changed in the name of the petitioner. Petitioner, my lord, is the fourth respondent before my lords, that Mysore Stoneware was transferred in, was changed in the name of the petitioner in respect to these two survey numbers, and also several other survey numbers of Chikkabanavara village, and the total extent of land is 21 acres, 21 guntas. Annexure E is the copy of the receipt patta, would demonstrate petitioners have paid Kandayam being in possession of the land right from the year 1961. These documents would make it clear that land in survey number 79 and 90 of Chikkabanavara village were acquired pursuant to sanction accorded by the then government on 15/6/1938 and continues to be in possession of the petitioner. That is, my lord, the fourth respondent, Mysore Stoneware, before your lordships. From the above, it is clear this court has already ruled that possession is taken by respondent number 4. Kandayam is paid from the year 1961. It is also found by this court that the fourth respondent, that is, my lord, fourth respondent before my lords, continues to be in possession of the property in question. If this is so, if it is so, the said question cannot be re-agitated by the petitioners by filing this writ petition. The questions which are already settled cannot be allowed to be re-agitated. Acquisition of the year 1938, petitioners cannot be allowed to question the acquisition after a lapse of 70 years. Submission of the learned counsel for the petitioners that the petitioner were not paid compensation also cannot be considered after 70 years from the date of acquisition. Accordingly, writ petition fails. Then, my lord, more important is, please come to, my lord, running page 596. Another writ petition was filed by Rajamma and others.
Now, this petition was by Ramdas.
This is Ramdas, my lord.
Who is Ramdas?
My lord, Ramdas was another person, my lord, who claims he was the owner of survey number 79 and 80 of Chikkabanavara. And my learned friend, my lord, here, they claim they are the owners of, my lord, 71, 72, 80/1 and 80/2. My lords may come to, my lord, 596 now.
What is Kandayam?
Kandayam is, my lord, the land revenue, my lord. Land revenue or tax, land tax.
Now, 596.
596, my lord, if my lords come to. If my lord sees, my lord Rajamma and my lord several others filed this writ petition. My lords may turn the page over, my lord. Respondent number 1 is Mysore Stoneware, the 4th respondent before my lords. Next page, please look at serial number 8. Jagadamba, my lord, the appellant before your lordships. Jagadamba, wife, my lord, the wife of E. Krishnappa, residing at number 1, Adakamaranahalli village, 21st KM Tumkur Road, Makali Post, Bangalore 1.
Who is she?
Appellant. Please, sorry. Please turn the next page, my lord, page 600. I'll tell your lordships why. 600. Paragraph 2, my lord, there is a tabular column. My lords, come to, my lord, the tabular column. My lord, may I read para 2, my lord, so that there's continuity. Petitioners are members of a joint Hindu family and are said to be legal representative on Chikkanna Reddy, who had filed form number 7 seeking occupancy rights in respect of the following lands. Which are the lands? My lord, 71/1. Sorry. In the tabular column, my lords get that. 71/1, 71/2, 80/1, 80/2. Same lands, my lord, which my learned friend, client is claiming. He is the 8th respondent in that writ petition. Then, my lord, please come to, my lord, running page 607, paragraph 6. My lords, para 6, my lord, at the bottom. Sorry, 607, my lord, bottom para 6. On these facts and circumstances, and from an examination of the record, it is not in serious dispute that respondent number 1 was conferred with the subject lands. Respondent number 1 is, my lord, the Mysore Stoneware, before the 4th respondent before my lords. Apart from other parcels of land, for the purpose of establishing its manufacturing unit of stoneware pipes, carrying on the incidental activity of mining for raw material. Respondent number 1 having engaged the service of one Patel Channappa for planting eucalyptus and casuarina trees from time to time, and cutting and removing mature trees while retaining a share in the wood, was a contractual relationship in the nature of service contract and has to be executed periodically. It cannot be said that there was continuous cultivation by way of agricultural operation, whereby the said Patel Channappa would claim as a tenant. He has not, in fact, claimed such rights. My lord, this wood was required, my lord, for the factory itself. It was being used, my lord, stoneware for that fire. My lord, this was all used. And, my lord, the writ petition is dismissed. Same lands, my lord, respondent before your lord, my lord, the appellant before your lordship is a party.
It is in my turn.
This has been affirmed by the division bench. Next page, my lord, 610. My lord, what is being done now? In fact, my lord, all this I have set out, my lord, in my list of dates in a chronological manner. I know, my lord, it's papers were too many, 4 volumes. So, my lord, I have kept them. What is more important is, on an earlier occasion, my lord, Justice Mohan Shantan Gowda's judgment at 619, this honorable court, my lord, specifically held, acquisition is complete. After 70 years you have come, therefore we dismiss it. My lord, the argument today is, my lord, he cannot overcome this judgment. So what does he do? He, my lord, engineers an application for, my lord, change of, my lord, revenue entries. What cannot be done directly cannot be done indirectly. My lord, I'm fortified by some authorities which I'll place before your lordships. He knows that if he challenges the acquisition, my lord, it will be dismissed, fully covered by this judgment of at to 619. So, my lord, he engineers a petition for, my lord, a kata change. It is standing in my name. So he says, no, it can't stand in my name. In fourth respondent's name, it should stand in my name. And
On what ground?
my lord, on the ground that he is the owner. He has purchased it from Rajamma, not this Rajamma, but some other Rajamma. Actually, my lords are aware, a subsequent purchaser has no right to challenge an acquisition. It is a well-known proposition of law. I don't want unnecessarily burden your lordships with authorities and authorities. But the fact is, what cannot be done directly, cannot be done, my lord, indirectly, is what the Honorable Supreme Court has held. I'll just pass on, my lord, one judgment for my lord's consideration. That is precisely what is being done now. First of the judgment, my lords, come to, my lord, page number 1 of this judgment. This is, my lord, 2003, 2 SCC 593, para 33, my lord, at page 11, my lord. The person whose lands were acquired, thus having entered into an agreement, cannot be said to have any legal right, which can be enforced in a court of law, so as to enable him to obtain an order from the court directing the Union of India to reopen the agreement, only because by reason of subsequent award, an enhanced amount of compensation has been paid for a similar class of lands. If a right to get an amount of compensation redetermined is held to be implicit in the act, the same for all intent and purport would amount to invoking the provision of section 28 of the Land Acquisition Act indirectly, which cannot be done directly. It is well settled principle of law. What cannot be done directly cannot be done indirectly. In our case, he knows, my lord, acquisition, my lord, can't be challenged. In fact, my learned friend, my lord, went on arguing the acquisition is bad, this, that, and all that. His whole argument was based on that. But what does he do? He doesn't, my lord, challenge the acquisition. He knows that, my lord, if he challenges the acquisition, it will be dismissed. Therefore, my lord, what can't be done directly, he seeks to do it indirectly, goes before the Tahsildar. Tahsildar, my lord, allows it. Thereafter, my lord, even before I file an appeal, he goes and, my lord, changes it. And therefore, my lord, his revenue records, which he has placed, are all, my lord, subsequent to that order of the Tahsildar. And the Deputy Commissioner, my lord, says, no, there is already an acquisition, it's all complete, and therefore, my lord, he sets it aside. Second judgment, please, my lord, please come to, my lord, the second one. Delay is fatal, my lord, to a writ petition. page 13, 1995, 4 SCC 683, paragraph 23 of this, my lord, at running page 23. It starts at 13, my lord, at 23. Paragraph, my lord, 23. Therefore, where a high court in exercise of its power vested in under Article 226 of the Constitution issues a direction, order or writ for granting relief to a person, including a citizen, without considering his disentitlement for such relief due to his blameworthy conduct of undue delay or laches in claiming the same, such a direction, order or writ becomes unsustainable as that not made judiciously and reasonably in exercise of its sound judicial discretion, but as that made arbitrary. Then, my lord, my learned friend went on saying, oh, this is a wrong judgment. My lord, order passed by your lords is a wrong judgment. Wrong judgment, my lord, inter partes, my lord, binds him. He is a party, my lord, in the second writ petition. My lords may come to my lord page 30. In this, my lord, para 15, my lords get that at page 35, my lord, 35. This is, my lord, AR 1962 Supreme Court, 1061, my lord. 66 Supreme Court, not 62, sorry, my eyes. Sorry.
66.
66 Supreme Court, my lord, I'm sorry. AR 1966 Supreme Court.
Para?
Para, my lord, 15, 15, my lord. Page, my lord, 35, my lords get that. Before proceeding with these arguments, my lord, page 35, para 15 at the bottom, my lords get that. Before proceeding with these arguments in detail, we can dispose of the second contention very shortly. This argument proceeds on a fundamental misconception, as it seeks to equate an incorrect decision with the decision rendered without jurisdiction. A wrong decision by a court having jurisdiction is as much binding between the parties as the right one, and may be superseded only by appeals to the higher tribunal or other procedures like review, which the law provides. This is, my lord, reiterated in, my lord, the next judgment. My lords get that at page 41. 1997, 2 SCC 552, my lord, para 41, my lords get that. 1997, 2 SCC 552, paragraph 4 of this judgment, my lord. My lord, can I persuade your lordship? Come to page 43, my lord. Placitum C. Last 4 lines of, my lord, that judgment. 5 lines. The law is well settled. Page 43, my lord, Placitum C. The law is well settled that even if erroneous, an inter-party judgment binds the party if the court of competent jurisdiction has decided the list. We therefore find no reason to interfere with interim dispute. He is a party, my lord. My lords have seen, my lord. He is a party respondent in the judgment, my lord, rendered by this court in Rajamma's case, which is confirmed by the appeal. And, my lord, he is a party in the appeal also. Therefore, my lord, it is not open to him now to say, that's a wrong judgment, it does not bind me. My lord, it binds him. That's why I said, first, my lord, challenge is to, my lord, the acquisition in an indirect manner, not permissible. Secondly, my lord, there is an enormous delay. 70 years earlier, now, my lord, 84 years. Then, my lord, I'll take another 10 minutes. Maybe, my lord, any date convenient to your lordship, my lord, I'll come.
They are not there. Petitioner is there.
I think, but he was.
You can.
My lord, the next judgment, please come to, my lord, page 44.
You can complete the judgment.
Yes, my lord, I'll complete it. My lord, revenue entries in, my lord, revenue records do not confer title. My lord, that's a well-known concept. My lord, I kept through judgment for my lord's consideration. My lord, I'm sure, my lord, this would be cited before your lordship any number of. Then, my lord, more important is the Tahsildar, my lord, has gone into, my lord, title. He does not have right. In fact, the last judgment, a full bench judgment of this honorable court, my lord, page 60. My lord, this is ILR 2002 Karnataka 2750, a full bench judgment of this honorable court. Please, my lord, at paragraph 8. At page 66, my lords get that. Can I persuade your lordship, my lord, come down, my lord, in paragraph 8 to (13 lines from, my lord, in the middle, my lords get that, my lord. Therefore, it becomes clear. Sorry, my lord, 13 lines from the top of paragraph 8. Therefore, it is clear. In the middle, my lord, somewhere in the middle of that paragraph, my lord.
Therefore, it becomes clear.
Yes, my lord. Therefore, it becomes clear. Every revenue officer who is authorized to hold an inquiry in respect of disputed cases is a revenue court. The very fact that he is prohibited from recording the statements and depositions of the parties makes it clear that no substantial rights of the parties in respect of the disputed property can be gone into by such revenue court. If title or right to set up by one party to an immobile property is disputed by the other party, such title to the property cannot be inquired into by the revenue courts, much less any decision be rendered for any purpose whatsoever. In the first place, revenue courts constituted under the Act can only go into the questions of assessment, recovery, land revenue, and land revenue administration. It has no jurisdiction to go into the question of title in respect to the immobile property. In fact, Tahsildar is a revenue court, my lord, under the Act, Land Revenue Act, my lord, if your lordship's take, my lord. Idea. Take it. Can I persuade your lords? Sorry, 24 could decide.
Section 20.
Section 24. But a revenue officer, not below the rank of a Tahsildar, while exercising power under this Act or any other law for the time being in force, to inquire into or to decide any question arising for determination between the state government and any person or between parties to any proceeding, shall be a revenue court. this honorable court had specifically, categorically held, he can't go into the title at all. And I'll point out, Tahsildar went into the title.
Can't do.
Go into the title of the property
Oh,
with regard to immobile properties. My lord, any number of judgments are there. I just wanted to, my lord, reiterate that. That, my lord, the Tahsildar acted like a revenue court. And, my lord, this honorable court held in the full bench decision that revenue court can't go into the title. One is, my lord, entries do not confer title. That, my lords, my lord, every day your lordships, my lord, will be citing before your lordships. Record of rights have no evidentiary value with regard to the title, my lord, is also, my lord, I've kept one judgment.
Even
also.
if your friend succeeds, your title is in.
In fact, my submission to your lordships is, first of all, my lord, he's a subsequent purchaser. Who is, my lord, after, my lord, 70, 80 years, my lord, purchase the property, comes before the, my lord, he knows that he can't come directly, goes before the Tahsildar, engineers, my lord, a litigation. And if your lordship look at, my lord, order the Tahsildar for a minute.
But he is saying that there is no final notification. That is.
My lord, my submission to your lordship is that this juncture, my lord, it's not permissible for him to raise all that at all.
That you are. After
Yes.
70.
Absolutely, my lord, 84 years later, my lord. And, my lord, what has happened is, there is a presumption, my lord, what happens is, my lord, those old file, my lord, records, we don't get it now. 114 of the Evidence Act, my lord, specifically says all officials act are deemed to be done, my lord, properly and regularly and correct manner and lawfully. Of course, I didn't want to, my lord, unnecessarily burden your lordships with authorities, but that's the proposition of law. Therefore, my lord, that's why I said, look at, my lord, the conduct of this person. He, my lord, purchases a property. He is not able to, my lord, challenge the acquisition because acquisition has become final. My lord, your lordship's order specifically, my lord, spells out that, my lord, it has already been, my lord, I've set up a factory, it's running, and, my lord, the possession is with me. Kandayam, I am paying, my lord, the property tax, I am, my lord, in possession. He is a party in the other proceeding, my lord, where Rajamma, my lord, says, I am the tenant of these four lands. Of course, he says that Rajamma is different, this Rajamma is different, but does not matter. That, my lord, it relates to those 4 lands, which, my lord, he today claims is apparent, my lord, from the very order, my lord, passed by this honorable court, which affirmed, my lord, which is affirmed by the division bench. Therefore, my lord, my submission to your lordship says, this is one such case where, my lord, it's a speculative litigation, which was engineered, my lord, in a very, my lord, innovative manner. That's all that I can say. Then, my lord, if your lordships, my lord, just turn to, my lord, my list of dates for a minute. Should I, my lord, continue another 10 minutes or I'll come, my lord, another day, subject to your lordship's convenient, any date, my lord. Whatever date.
One PIL is to be, where is that? Mr. Kamath is not here.
This gentleman, my lord.
Call out that matter. We'll continue with, we'll continue on Monday.
As your lordship, please.
So you are now showing what? Next.
My lord, I'll be showing the Tahsildar's order, all that, my lord, so that, my lord, I'll, my lord, wind up the whole thing. And also, my lord, reply because they produce one document which is fabricated. I pointed that also.
Fabricated.
Yes, my lord. So-called cancellation of, my lord, that acquisition.
Number 60. Shreyas S. Kumar.
Petitioners.
Learned Advocate General is not there, short accommodation.
Will Lord, may it please your lordships. May it please your lordships.
Yes.
It seems that they have abruptly stopped the work now. The either the body or the truck has not been retrieved so far. At
So they have stopped.
least he has been, he has to be brought out dead or alive.
I appear for respondent number 1, my lords, behalf of ASG, my lords. Senior on his legs, my lords. ASG on his legs, my lords.
Pardon?
ASG on his legs, my lords.
He's on his legs.
Please, my lords.
So we can take up on Monday, Mr.
Yes,
ASC
yes, my lord. Yes, yes,
ASC is on his legs, therefore, no way out.
yes, yes, my lord.
Monday, Monday in the beginning will.
Yes, yeah. I'm
Obliged.
Grateful.
Obliged.
Serial number 59 was not. Serial number 59 was not called out, madam.
59 was not called out because the altered matter was taken.
Can it be taken up on Monday at 2:30? Like I had mentioned, my lord, on that day.
7.
7th? Grateful. Would it be possible one indulgence, 2:30?
We'll take up reminders.
7th, grateful.
My lord, in serial number 48, interim order may kindly.
Serial number 70, the petitioner is an ex-serviceman, my lord. He had served for 17 years. This matter is not reached. Along with submission, it's only just notices to be ordered by this honorable court.
In the first week of September. So that it can be taken up. That is the only idea. 7th September. 7th is holiday. 5th September.
My lord, I have a small submission, Your Honor. My client is a senior citizen, physically handicapped, general manager, grade 9 in public sector, HL. He is a handicapped. His missus is a cancer patient. She has to undergo surgery. After retirement in May 22, in July 22, it dismissed him from service, withdrawing all the benefits. 60 lakhs they recovered, and now they are not even given the lifeline. This is my prayer. If you give me one, just 10 minutes I can submit, Honor. Not today. The next day, whatever day I'll do. But kindly accommodate a little earlier, Your Honor, please.
Lord, that is serial number 50.
27 August.
Much obliged, Honor.
Okay. Tomorrow.